Delivery of order. Item number 1.
Item number 1 is wrongly listed. So, production listen. Yes. The bail application number ought to have been 2294/2024. So it will be Mr. N. Burman. N. Burman is there. It will be delivered at 2.
Two.
For reasons mentioned in the order, the petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount with certain conditions.
Item 3.
Jilik Ghosh, some clarifications are required. So, you and NCB, I have some queries. So at 2, we will take it up. You have submitted, I have some queries. Today at 2, we will take it up and thereafter I will deliver the order.
Item 4.
Hassan Basri. For reasons mentioned in the order, the prayer for bail of the petitioner is rejected at this stage.
Item 5.
For reasons mentioned in this order, the prayer for bail of petitioner is rejected at this stage.
Item 6.
For reasons mentioned in this order, the petitioner is allowed to go on bail of rupees 30,000 with 1 surety of like amount, subject to certain conditions.
On a regular bail application, that your lordship has already called for case date. But unfortunately, lordship, it was a POXO case. Notice to respondent number 2 has not been issued. That matter has already been fixed on 18th of August, lordship. May I say, lordship, only for issuing notice to respondent number 2 can it be taken up to tomorrow, lordship?
Okay.
Like,
Please note. But I beg to mention for listing of a criminal petition, my lord. Here was called for.
Criminal petition senior court.
My
There
lord,
are-
there is POXO matter.
There are 3 courts taking up criminal petitions. And this one is the junior most court.
And POXO matter is here.
POXO matters only in respect of bail.
May I please, your lordship? But this bail, my lord, AB, on last occasion of 21st July, my lord, matter was listed. And earlier also listed, unfortunately was not reached, my lord. So maybe kindly come up on, my lord, 7, my lord.
7.
Yes,
Okay.
may I please, your lordship? Lordship, I beg to mention a bail application for withdrawal, lordship. Tomorrow, lordship.
Okay.
Obliged.
May I please, lordship, one matter, lordship, that matter was taken up on 30th, lordship,
What matter?
POXO matter, lordship, or bail, lordship. It's a sheeted case, lordship. Your lordship was pleased to fix the matter on 80. But what happened, lordship? I was there, lordship. Your lordship was pleased to issue notice upon the respondent number 2. But in the order sheet, there is no such mention of, we have already taken steps, lordship. Nothing about notice, lordship. So we have taken a step on 31st, lordship, on the next day, lordship.
Now, what is your prayer?
My prayer is to leave the matter tomorrow, lordship.
For issue that issuance of notice?
Notice.
Okay.
May please your lordship, my lord, item number 47 to 49. State has filed a short objection to the bail petition. I pray before this lord or court that this matter may kindly be taken up on Thursday next. I'll just go through their objection. 47 to 49.
Heard Mr. B.D. Kaur, learned senior counsel, appearing for the petitioners who prays for an adjournment so as to enable him to go through the objections filed by the state respondent. The prayer is allowed. Let this matter be listed
8. Friday,
on 8th.
we are blessed.
Maybe the first, I like to mention, I don't know, 41 maybe with your lordship, which is already arrested. Lordship.
Heard Mr. What is your name?
Yes, sir.
Heard Mr. A. Islam, learned counsel for the petitioner who prays for allowing the petitioner to withdraw the instant anticipatory bail application as the petitioner has already been arrested. So, considering the submissions made by learned counsel, the prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
His lordship, I beg to mention item number 17, my lord. My lord, the arguing counsel ML Pandey is out of station, my lord. No, over telephone. Item number 70 for admission.
You have informed the legal aid counsel. You inform her. I am adjourning it.
My lord,
Heard on request of Mr.
that's okay.
M.H. Soikia, who submits that as the learned counsel for the petitioner, Mr. M.L.
ML Pandya.
M.L. Pandya is out of station. An adjournment is prayed for, same is allowed. Let this case be listed after 2 weeks on a date to be fixed by the registry.
Like to mention item number 32, Lord. CV is not been received.
32. Heard Ms. J. Singh for learned counsel for the petitioner, also heard Mr. K. Parashar, learned additional public prosecutor who seeks some more time for producing the case diary. The prayer is allowed. Let this case be listed. You are on interim. When you can be, you will be, Putul suggests 18th of July and 18th of August.
For withdrawal, item number 7.
May I please, your lordship?
Not Mr. K. Thakur. Why are you withdrawing?
Chief, sir instructed us to approach the trial purpose.
Heard Mr. K. Thakur, learned counsel for the petitioner who prays for allowing the petitioner to withdraw this instant bail application. Stop. The prayer is allowed. This bail application is dismissed on withdrawal.
Keep your.
Will be item 8.
Wait, your lordship. My lord, the petitioners were arrested on 16th of July. And my lord, they approached this honorable your lordship, my lord, on 23rd of July, and your lordship was pleased to reject their petition, bail petition of both the petitioners on the ground that it was too early and the investigation was, my lord, at a very nascent stage. Now, my lord, they have approached your lordship for the second time. The allegation in the FIR is that, my lord, there is a resort in Sonapur called, my lord, Nirvana Resort. And my lord, the police raided it and found that some of the boarders were possessing some my lord, some materials are used for gambling normally from their occupation. Now the petitioner.
Connected matters are fixed for hearing today. Other matters are fixed, where case diary is also available. We'll take it up along with those matters. Which item?
22 and 23.
Along with 22 and 23, we'll take it up today.
Just a small query. If it is not inconvenient, Lordship, can it be taken up after some time, Lordship? Because the CD is on its way, Lordship.
We'll take it up in the second half if you
2 o'clock.
add to.
Nine.
Finally, also for time being.
Same, Lordship, still related to the same case, Lordship.
Deepak Saikia. Add to.
Till 10.
Who is your senior? S. Munir. Okay, add to.
May I please, Lord? A regular bail application, my lord. FA read page number 11, my lord. So 13. FA registered under section, my lord, 22C of Adminis Act.
22C. What is your ground?
This case, from the petitioner, my lord, nothing has been required. He is arrested only, my lord.
We'll call for the case diary. Heard Mr. H. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Call for the case diary. Lease this matter on 28.
11, 11 of same case diary.
11 is also same. 11 also 28, same council. Item number 10.
12. This is regular bail application, Lordship. Lordship, the FI will find page number 11. Lordship, and some misunderstanding. Operating person, may I read, Lordship, page number 16. Very small FI, Lordship. Or is it particular, Lordship?
376. What is your ground? We'll call for the case diary.
Submission, Lordship. Just for a moment, may I read, Lordship? Now,
Yes.
Lordship, settled. Purvak beneath.
What is your submission?
FI loss after 3 years since the date of occurrence, Lordship. At that time, Lordship, the victim was 16 years. Now, Lordship, they are going to arrange their marriage. Now she is attaining the age of majority, Lordship. 19 years now, Lordship. And Lordship, for the informant, Lordship appeared and they have shown the affidavit. Now she is major, Lordship. Yes. For a moment, Lordship, may I read, Lordship?
Since when you are behind the bars?
13 days.
We'll peruse the case diary. We'll fix short date. Which police station? Since when you are behind the bars?
2025. As of today, 13 days. My little submission, Lordship, they will be arranged the marriage very shortly. So otherwise, my landed friend already appeared for the informant.
But we have activated a video bit, Lordship. Completed.
By the informant father of the. That is, everything may be recorded in
In the time of incident,
You file an affidavit. Today at any time.
we file affidavit within 2 days. Lordship.
Let them file the affidavit. Okay.
Statement of the girl, affidavit by whom?
Affidavit by informant, father of the.
But victim statement is.
Yes. We will fix a very short date.
Now, Lordship, victim is 19 years old.
Okay, no, we are not saying that we are against it,
They're going
but we have to
arrange the
peruse
marriage.
the case diary.
Informant is going to arrange the marriage of our daughter.
When? when the marriage is fixed.
Now she is in behind the bar, Lordship, and after Lordship,
If he is released from the behind the bar, Lordship, that's after that, we arrange the marriage.
their life is miserable.
Let us see what state victim has stated.
12 months.
Heard.
It's coming, all the police.
No, if CD does not come, you press for bail on that day. Heard. Mr. H. F. Hawk, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. The Mr. What is your name? Mr. A. Alim Sheikh has appeared and submitted that he's appearing for this. You have filed Wakalatnama.
Yes.
He's appearing for this respondent number 2/informant and seeks leave of this court to file an affidavit stating there that file an affidavit. He submits that the informant is not opposed to grant of bail to the petitioner as the victim girl who has now attained the age of majority will be married to the petitioner after he is released from the jail. Stop. Let the case diary be called for. Let this case be listed on 12th. The informant may file affidavit before the said date. List accordingly. 12.
13.
NBS commercial case, my lord, CD.
Heard Mr. A. K. Azad, learned counsel for the petitioner. Also heard Mr. K. K. Parashar. Call for the case. K. K. Parashar, learned additional public prosecutor. Call for the case diary. List this matter on 26/8.
7 করে দেবো 26
27/8.
25th is holiday, so 27 মানে
Item 14.
May I please, your lordship, this matter will move from the senior advocate A.S.R. Chaudhary. He's late, he's coming, lordship. So kindly pass over the matter for time being, lordship.
Okay. After some time.
Item 15.
This matter taken up along with item number 20 and 21. Arising out of the same of
20 and? Okay, wait for your turn.
Item 16.
Yes, Lordship, similar matter is fixed tomorrow for CD, Lordship. 1790, the connected matter. That's item 30, be taken up tomorrow 2 p.m.
Heard Ms. T. Som, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that a bail application of the co-accused, that is BA number 1790, AB number 1790/2025 is fixed tomorrow. And in that case, case diary has already been called for. Therefore, she prays for listing this matter along with the aforesaid AB case. Case number 1790/2025. The prayer is allowed. List accordingly. Not 2 p.m. in due course.
Okay.
Bail hearing via item 18.
May I please, your lordship? 483 application, my lord. The case is in trial stage, my lord. And 3 numbers of witnesses has been examined. Victim, informant, and other independent witness has been examined, my lord. And I am behind the bar for 11 months. So is there, my lord.
Service report is still awaited. Lord.
Oh, you find out. You can take information regarding service report. Over telephone. When?
It will also directly.
Today it is possible.
Today.
At 2, in the second half. Let him find out.
Item 19.
Same submission.
21 is also from the same FIR. I am for 19 and 21.
Poxo matter.
Unlawful activities prevention act along with the BNS.
We are taking up 19.
19 on net. Lordship, can you peruse the FIR on Lordship page 16? The section is the operating.
Investigation is going. See, case diary is there.
May I read the FIR? Lordship?
Yes.
With reference to the subject cited above, I have the honor to submit that reliable and actionable intelligence has been received from a credible source, indicating the presence and operational activities of certain overground workers or linkmen of the prescribed organization Alpha Independent, Alpha I in Guwahati. As per the input, these individuals have allegedly established a covert base in the Guwahati city with the intention of orchestrating subversive and anti-national activities, including but not limited
UAPA Act, unlawful activities. Yes, continue.
Lordship, waging war against the state in furtherance of the objectives of the said band outfit. The information further reveals that the aforementioned individuals are directly associated with James Assam, a self-styled commander of Alpha I, and are reportedly engaged in the collection of illegal funds through extortion. These funds are believed to be utilized in supporting and facilitating the operations of Alpha I, thereby contributing to the continuation of Alpha activities, unlawful activities against the sovereignty and integrity of India. In light of the sensitivity and gravity of the matter, the intelligence was promptly shared with higher authorities. A preliminary inquiry was accordingly initiated, and relevant technical inputs were analyzed. Based on the findings, 3 individuals were examined. The subsequent inquiry and analysis technical details suggest that direct link with Alpha I. These findings provide reasonable grounds to believe that the individuals in question are functioning as active overground workers of the band organization. It is also apprehended that other such overground workers may be clandestinely operating in and around Guwahati, posing a significant threat to public order, internal security, and national integrity. In view of the above, it is respectfully requested that an FIR be registered under appropriate provision of law, including section 10 and 13 of the Unlawful Activities Act 1967, along with relevant sections of the BNS. And that appropriate legal action be initiated for it, ensure that such activities are curbed and the individuals responsible are brought to justice. Initially, Lordship, 3 persons were arrested. The number 1 is Y Nemkha, 2 Yaman Konyak, and S Hangmai Konyak. I am not for these 3 persons, Lordship. These 3 persons are already enlarged on bail. This bail order is on page 33 by this honorable court. Page 33, the observation, there are some observations. Page 33 is a base order. The operational personnel, the paragraph 10, 11, and 12. I am reading the paragraph 10. Under the given circumstances, this court is of the opinion that keeping contact with other people does not amount to an offense if it is not proved that the said contact has led to commission of an offense. 11. I have decided to agree with Mr. Chaudhary, learned counsel for the petitioners, that in the FIR, no names are mentioned from whom money was collected. Even the case diary does not have the names of those persons from whom money was collected. Number 12, under the given circumstances, this court is of the opinion that the petitioners do not deserve to be detained in custody for any further period of time. It's an observation. There's no allegation is there that we are making extortion, Lordship. The FIR is not by any individuals. The informant himself is a police officer, Lordship. There is no allegation from any individuals, any entity, any company or other persons. Lordship. It is the informant is the Lordship, Dr. Shankar Jyoti, not.
No,
is,
it is obvious because it was on specific intelligence input. So it would be by a police officer.
For that purpose, one thing, Lordship, I have taken for 7 days in police custody, Lordship. Kindly peruse the, after 7 days, I have been reproduced, that is page 30. Page 30. Page 30, Lordship, paragraph 3. After cert, paragraph 3.
Yes.
Lordship. That the thorough custodial interrogation of the accused persons noted below, namely Sri Himanshu Das, alias Baba, age 32 years, and Sri Rupjyoti Boru, alias Munna, age 50 years, has already been completed. Lordship, this is after reproduction, after expiry of custody.
No, what is your submission?
My submission is I am no way involved, Lordship. I am not a member of Alpha, Lordship. I have never made any demand to any persons. There's no complaint against me, Lordship. I have been falsely
And the
indicated.
coordinate bench has granted bail to the named accused.
Yes, Lordship. They are the FIR persons. The allegation levels against the FIR persons, the same allegation leveled against us. The ground of arrest are same, Lordship. Not similar, same, Lordship. Same allegations, Lordship. They are already on bail, other 3 persons.
Yes.
Same allegations.
What is the date of your arrest?
2025. Today it is 39 days. I have the forwarding report of the earlier 3 persons, the same ground of arrest. In that ground of arrest, it is also said that they are directly linked with the Alpha persons working for the Alpha persons. Same allegations, Lordship. Same ground of arrest.
My lord, if the argument is made altogether for all the persons, it will be better, my lord. He is for 21 also, my lord.
Yeah.
He is.
All are arrested on the same date. On the
Yes,
same
all
ground
are
of
arrested,
arrest.
my
In item number 21, 21 South Putul. 21.
21 is a petitioner.
Same submission.
Same 21 also. Same FIR, Lordship. We have been provided on the same day. On the
How
same
many similar cases are there?
1921 and one person, my lord, that 15.
I am.
Okay, let us take one by one.
My lord, it will be better for to address the court for my lord.
But I have to,
But regarding the Siraj Hazarika,
no, let us go one by one.
but okay, my lord.
Against the present petitioner, what is your
Yes,
submission?
main, my lord, Siraj Hazarika, just I am saying one line.
Himanshu Das.
Himanshu Das, I am coming now. Siraj Hazarika alias Dinesh Osam. He is a veteran Malayalam activist of Alpha Malad, and he involved in recruiting these Malad persons, Himanshu Das and Lintu Gogoi. Himanshu Das is newly recruited, Malad, and he is also involved in extortion of money and all this. And Lintu Gogoi also. These persons are newly recruited persons, my lord. But Himanshu Siraj Hazarika, he is a alias Dinesh Osam. My lord, there are several materials, my lord, materials the case diary, and Dinesh Osam, my lord, once, my lord, he approached the DGP also to surrender himself. There is a certificate from the DGP that he want to surrender regarding Dinesh Osam. So it implies that he is a active member of Alpha. But at that point of time, the certificate of 2017, it is mentioned in the certificate that, however, if any suspicion movement is observed it should be brought to the notice of the undersigned immediately. So he didn't surrender at that point of time. Since 2017, that is the certificate, part of the CD, where it is mentioned that Rikshirat Hazarika alias Dinesh Assam is want to surrender and come to the mainstream, want to come to the mainstream. Certificate of 28th of December 2017 of from the DGP office. But till 2025, 8 years gone by, he has not surrendered. And he has continued his activities and mainly recruiting the new members in the main organization. And this Himanshu Das and Lintu Gogoi. These persons were arrested 37, 38 days only, my lord. And UAP is there, my lord. In investigation is very initial stage. Yes, at the point of time, my lord, in the affair, only 3 persons. They are collecting only names from where, my lord, extortion can be made. Those persons were allowed by the coordinate band.
No, Lordship, it is direct allegation against earlier 3 persons, Lordship.
Let him.
Those persons were, my lord, collecting names and in some cases extortion. Well, these persons, those persons were overground, and these persons are not on in similar footing, my lord. This Himanshu and item number 15, Lintu Gogoi, these are newly recruited and recruited by Rikshirat Hazarika alias Dinesh Assam. My lord, there is the CD, there is a certificate from the DGP at that point of 2017, but not yet.
But there is an observation
Yes, sir.
of the IO that thorough interrogation has been done of Rishiraj as well as and
Interrogation has been done.
has already been completed.
2 persons, my lord, yes. 2 persons investigation is still going on, and 2 persons arrested, this Himanshu and Lintu. How many persons he may again, my lord, he there will be other persons also where, my lord, he has recruited. Those are still in the ban organization, my lord. So very natural stage, my lord, 37, 38 days. Is registered under 10 and 11 of the UAP, my lord. So because of that, I have mentioned, my lord, all the cases may be taken together, and one, this Rupjiti Boro,
No, one by one.
my lord, one by one, there are materials, my lord.
Heard Mr. What is your name?
PK Sohoi.
PK Soheria, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned additional public prosecutor. This application under section 483 of BNS as 2023 has been filed by the petitioner Himanshu Das, who has been detained behind the bars since 27/6/2025 within bracket for last 39 days in connection with Crime Branch PS case number 2/2025 under section 61 within bracket 2/147/308 within bracket 2 of BNS, read with section 10/13 of the Unlawful Activities within bracket Prevention Act 1967. The gist of accusation in this case is that on 29/4/2025, one Dr. Shankar Jyoti Nath, Inspector of Police, had lodged an FIR before the officer in charge of Crime Branch PS Police Station, Inter India, alleging that 3 persons named in the FIR, namely Y. Nemka, number 2 Yaman Konyak, number 3 S. Hangmai Konyak, are engaged in conducting operational activities of as overground worker or linkman of the proscribed organization, that is Alpha within bracket independent. It is also alleged that they are also engaged in collection of illegal funds through extortion and engaged also in other illegal activities. So, learned counsel for the petitioner has submitted that the petitioner is an innocent person and has not been named in the FIR. He further submits that the petitioner has been detained behind the bars since 27/6/2025, and he was also remanded to police custody for 5 days.
7 days.
For 7 days. And after completion of the police custody, the investigating officer in his report submitted to the magistrate, learned judicial magistrate, has stated that the interrogation of the present petitioner has completed. He, learned counsel for the petitioner, also submits that in the meanwhile, all the three named accused in the FIR have been granted bail by a coordinate bench of this court. In the case of bench of this court on 18/6/2025 in bail application number 1895/2025. He submits that the accusations were leveled against the named accused persons only. And considering the period of detention and the fact that the co-accused persons are granted bail, he may be allowed to go on bail. On the other hand, the additional public prosecutor, Mr. K.K. Parashar, has produced the case diary of Crime Branch PS case number 2/2025 and has vehemently opposed the grant of bail to the petitioner at this stage. He submits that the petitioner was freshly recruited by co-accused Rishiraj Ajurika alias Danish Assam, and he has been engaged in the activities of extortion and other illegal activities. It is further submitted by learned additional public prosecutor that the investigation is still at initial stages, and therefore he opposes the grant of bail to the present petition. I have considered the submissions made by learned counsel for both sides. On perusal of the records, it appears that the investigating officer, while forwarding the petitioner after completion of the period of police custody before the court of learned Session Judge Kamrup Metro, देवी सेशन जज लिखा जहाँ मजिस्ट्रेट लिखा था, सेशन जज कामरूप मेट्रो, had mentioned therein that thorough custodial interrogation of the present petitioner has been done. And an interrogation of the present petitioner has already been completed. Stop. It also appears that the co-accused persons who were named in the FIR have already been released on bail by a coordinate bench of this court. Under such circumstances, under above circumstances, this court is of considered opinion that if though, there are incriminating materials against the petitioner in the case that, if he cooperates in the investigation, his custodial interrogation may not be necessary for completion of the investigation of Crime Branch PS case number 2/2025. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Session Judge Kamrup Metro with following conditions. 1 and 2. Number 3 of the book. The petitioner shall appear before the investigating officer of Crime Branch PS case number 2/2025 every week for next 4 weeks or till the investigation is completed, whichever is earlier. Stop. Any violation of the conditions of the bail, any aforesaid conditions would be good ground for cancellation of bail granted to the petitioner. This application is accordingly disposed of. Send back the case. Yes, next 21. What is your submission?
Plus 21, almost submissions are same, Lordship. 21, regarding 21, the petitioner Rishia Hazarika was arrested under same grounds of arrest. Only difference is that Rishia Hazarika was taken for 14 days in police custody. That they got enough time to interrogate the Rishia Hazarika. And the moreover, the FIR accused persons, the allegations are same with the present petitioner. They are already enlarged in persons. In the FIR, the allegation against the earlier 3 petitioners, the same that they are linked, they are associated with the Alpha. They are the overground workers of the Alpha.
Agor.
It is nowhere mentioned from whom regarding the certificate also, regarding whom he has recruited, that is mentioned alone. No. And during investigation certificate.
I heard Mr. P.K. Soharia, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Rishiraj Hazarika, alias Honto, alias Danis Assam, who is detained behind the bars since 27/6/2025 in connection with Agor case. So the list of accusation same. The submission of learned counsel for the petitioner almost same. Learned additional public prosecutor submits that the petitioner stands on different footing from that of the co-accused persons who were granted bail by the coordinate bench. He submits that the named accused in the FIR were alleged to be overground workers of the proscribed Alpha I organization, whereas the investigation reveals that the present petitioner is engaged in recruiting fresh people in the proscribed Alpha organization. He submits that there are materials in the case diary to indicate that he is an active member of Alpha I organization, as in the year 2017, it is there in the case diary that he approached the DGP in 2017. He also approached the Director General of Police with an proposal of surrendering before the government. However, he did not honor his promise. Learned counsel for the petitioner submits that learned additional public prosecutor submits that the petitioner has been the role of the petitioner is continue. The petitioner has been detained behind the bars only for how many days?
39 days.
39 days. And the investigation would be hampered if the petitioner is released at this stage. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of Crime Branch PS case number 2 of 2025. It appears from the case diary that the present petitioner, who against whom the allegation is of recruiting fresh people in the proscribed Alpha organization, stands on a different footing from the co-accused persons who are released on bail by the coordinate bench of this court. Considering the stage of investigation and the incriminating materials available against the petitioner in the case diary, this court is reluctant to grant bail to the petitioner at this stage. For aforesaid reason, the prayer for bail of the above named petitioner is rejected.
May I please, Lordship? One, my submission may be recorded, Lordship. As per instruction, I never approached the DIG or any police official with a letter to surrender, because I'm not a member of Alpha. That may be recorded, Lordship, because I can prove it.
After submission of learned PP, in response, learned counsel for the petitioner submits that the submissions made by learned public prosecutor are not true, as the petitioner never approached the Director General of Police with an offer to surrender as a member of proscribed Alpha I organization. He submits that the petitioner has never been a member of Alpha I organization. Stop. Baki as it is. Okay. Now it is rejected. You continue your investigation.
Privilege.
Item number 15. Recruitee, he is a fresh recruitee. Heard Mr. B.K. Gogoi, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Lintu Gogoi, who has been detained behind the bars since 28/6. How many days?
13 days.
Date of arrest is same.
Same, but Lordship, because I have recorded it wrongly, or start 28. It should be 27, Lordship. And it posted.
27/6, within bracket 38 days. Remaining everything. What is your submission?
Oh, Lord. Even Lordship, the Amicus are already released on bail, Lord.
Same submission. 30,000 with 1/7. And you have to appear before the IO
Lord.
for next 4 weeks, every week. If you default, your bail will be cancelled.
Obliged, Lord.
20.
Same forwarding report, Lordship, same allegation. I am for root duty borrow, Lordship.
He is Mr. Parashar. Is he a member? Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor.
Forwarding report. And keeping contact with some other.
Okay. Application under section 483 of BNSS. Under section same. Gist of acquisition same. You were also remanded to police custody. For how many days?
14 days.
Remanded to police custody.
14 days was short, 7 days was granted.
Submission same. The PP submission is different. Learned counsel, learned additional public prosecutor has produced the case diary of Crime Branch PS case number 2/2025 and has opposed the grant of bail to the petitioner on the ground that there are materials on record to indicate that the present petitioner, though a surrendered alpha militant, was in constant touch with co-accused Rishiraj Hajorika alias Danish Assam and has been helping him in commission of illegal activities. Baki, same, 30,000 with 170. You have to appear before the IO.
Therefore, I have heard.
Same condition is applicable.
Much obliged, your Lord. Much obliged.
Item 22.
This matter was already heard by your lordship the other day.
Miss,
Just highlight the few points.
similar matter is fixed at 2. At 2. We'll take it up together. Oh, 3 matters are fixed. We'll take it up at 2.
title owners and all.
But same case, we have to again open the case there. All matter relating to that resort will be taken up at 2.
Standing item 14.
But you lost it. Regular bail, madam, the cattle, carrying the cattle without that here, madam. And going to the animal act, realize the cattle act, along with theft, madam. You kindly see the FIR page 9. He was not there, and subsequently he was arrested madam, after about 20 days. Page 9 is there. Everything seized, 10 cattle were there, madam, seized, bike seized, mobile seized, everything seized. Thereafter, it was found that the petitioner, present petitioner, he is the owner.
The accusation is of theft also.
Yes, theft also, but nobody has claimed. From the FIR, it does not say it is theft also, my lord. I am claiming it is my, I purchased it might have through some other persons, my lord. For sale. It is there, your lordship, can see page 9. From the FIR itself, it shows, my lord, your lord, can see. Data proceeded to the place of occurrence for investigation of the matter, and after appearing in the place of occurrence.
Why the prayer was rejected by?
Yes, only serious offense and circumscribable.
Yes, Mr.
Yes.
10 cattle
Yes, that is, I am not denying, madam, but so far the present petitioner is concerned, my lord. He was not there at all. So only
We will call for the case.
madam, 16, 17 days, almost 16 days, madam. Further, everything ceased. Whether any city will improve anything, madam.
No, we don't know what is there in the case diary.
No, but from the FIR, madam, everything ceased. FIR ceased.
Mm,
Only by the city for the purpose of while calling your lordship may call, but
We are fixing short date. Heard Mr. H.R.A. Chaudhary, Mr. Learned Senior Counsel, assisted by Mr. A. Ali, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor. Call for the case diary. When? Let this matter be listed on bail.
Item 54 from supplementary list. Item 54.
None has appeared for the petitioner on call. List this matter day after tomorrow. Day after tomorrow is 6 on 6.
Item 55.
Fifty-fourth, show the presence of Miss N. Kakoti, Learned Counsel for the NCB is present. Day after tomorrow. LCR not received. 54th Dibu. It appears that the scanned copy of the trial court records have not yet been received. Issue reminder for the same. Place this matter 22nd on 22nd of August.
Item 55.
None has appeared for the petitioner on call. Mr. B. Sharma, an additional public prosecutor, is present. Office note dated 2/8/2025 shows that the notice issued to respondent number 2 has not yet returned. Learned additional public prosecutor is requested to get the information regarding the fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station, and let this court know about the same on the next date fixed. Let this case be listed on shorter 18th of August.
Item 56 and 57.
Please, this your lordship. My lord, in the last occasion, CD case diaries was full.
Yes, that is there.
Matter of fact, we already required. We have already called for the TCR Lord. In item number 57, Lordship. Rising out of the fire.
Okay. The scan copy has not received. In item number 56, 56, heard Ms. T. Crow, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. It is submitted at bar that though in this case diary was called for, however, in a connected case, it was informed that charge sheet has already been laid and scanned copy of the trial court records were called for. Same has not arrived. Stop. Issue reminder for trial court records. Let this case be listed when 12th. List this case on 12th of August. This next case, no order is required because it is already fixed on 12th of August.
Bail hearing, item 24.
May I please, your lordship? In this case, I'm an interim and appeared man.
You have appeared. Case diary is there.
As per my instruction.
No, whether he has appeared, any indication is there. Heard Mr. N. Mahajan, learned counsel for the petitioner, who submits that the petitioner was granted interim bail
20 of
by
April.
this court on 20 April,
20 February.
20 February 2025. And he has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor Mr. B. Sharma submits that the case diary available before the court is not up to date and no indication is there as to whether the petitioner has appeared before the investigating officer or not. Hence, he prays for allowing the prosecution side to produce an updated case diary. The prayer is allowed. Let this case be listed again on 29 August. The interim order shall continue till next.
I'm extremely sorry, my lord. I could not appear on item 55, my lord. Just my lord, my name.
Show presence of Mr. S. Ahmed in item number
55 of supply list, my lord.
55. 55, none appears question. Mr. S. Ahmed appears for.
Supply list, item 55. Obligement, much obliged.
Items 25 to 28.
Yes,
Please fix for CDO.
you are on interim,
Uh,
all of you. Yes, there is the, you have appeared before the,
yes.
And Parveen Sultana.
Oxo is there.
For the Rio.
The other cases, there was these two persons. This is Bilkis and another is Farhana. These are the two persons in whose name property is there. Lordship. However, this one of our husbands, I think Farhana's husband, he done that Bilkis lordship. He called this complainant. He received the complainant and he falsely lordship impersonate this person, Parvina Sultana and Atika Sultana. They were wearing lots of burqas and they were given money of 1,50,000 to and they signed this document lordship. And after all, later on lordship, these two persons denied this is they have not signed. So otherwise, materials are there and it is true lordship, metering is there. And I have found also the statement of Parvina Sultana and Atika Begum.
Parnaz and Bilkis,
Landowner, your lord.
you have appeared.
Peer, your lord.
You are appearing for informant. You have any submission? Okay, okay. Heard. In item number 25, Mr. H. Chaudhary. In item number 26, Mr. S. Hawk. In item number 27, Mr. N. Mahajan. In item number 28, Miss A. K. Tai. Separate order, no? Similar orders will be similar in separate order sheets. Also at Mr. K. K. Das, London Additional Public Prosecutor, as well as Miss B. Louder S. Sahi, Learned Counsel, appearing for the informant. Learned Counsel for the petitioner submits that the petitioners was granted interim bail by this court, and in pursuant to the directions of this court, the petitioner has cooperated in the investigation. On the other hand, Learned Additional Public Prosecutor has submitted that only statement of Parnaz, only statement of Parveen Ahmed alias Parveen Sultana, as well as Artika Begum have been recorded. And Farnaz? Okay. Okay then. Learned Additional Public Prosecutor submits that the petitioner has appeared before the investigating officer and her statement has already been recorded under section 180 of BNSS. On the other hand, Learned Counsel for the informant also submits that the matter has been amicably settled between the parties and the informant does not intend to pursue the matter and has no objection if the interim bail granted to the petitioner is made absolute. Stop. considering the submissions made by learned counsel for both sides, comma, as well as considering the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to her by this court is hereby made absolute. And this anticipatory bail application is disposed of. All four similar orders.
Obliged. Obliged. Item 29.
May I please, your lordship? Lordship, I am on an interim lordship.
You appeared,
Yes, lordship. On July 12th, lordship, I have appeared and fully cooperated with the investigation.
you have to appear.
That is, lordship, the fact is that after getting interim protection, 3 times I have appeared before the. But by this and that plea, he refused to accept, reject my, to record my statement, lordship. And thereafter, on last occasion.
You
that-
appear once more.
Yes, once more.
Once more
Yes,
you
sir.
appear.
Yes.
Okay. Heard Mr. R. Das, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner Vivekanand Taid was allowed to go on interim bail by this court on 16/5/2025 and in pursuant to the directions of this court, he appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Golpara PS case number 66/2025 and has submitted that though the petitioner had appeared before the investigating officer, however, his presence was further required by the investigating officer for the purpose of investigation. And when he was requested to appear before the investigating officer, he did not comply with the same. Stop. I have considered the submissions made by learned counsel for both sides. Considering the submissions made at bar, the interim bail granted to the petitioner on 16/5/2025 is hereby made absolute, subject to condition that the petitioner shall again appear before the investigating officer of Golpara PS case number 66/2025 within a period of 7 days from the date of this order. This bail and cooperate in the investigation. This bail, anticipatory bail application is accordingly disposed of.
Item 30.
They are on interim. Heard Mr. F. Hock, learned counsel for the petitioner. Also heard Mr. K. Mr. B. Sharma, learned additional public prosecutor, who praised for some more time for producing an updated case diary, as the case diary available before the court is not updated. The prayer is allowed. Let this case release listed on 28A. The interim order shall continue till next day.
Obliged.
Item 31.
May it please your lordship, out of the same PS lordship, one bail application has been fixed on 18/8 lordship. Item number 32 lordship.
When?
18/8 lordship.
18.
And lordship postmortem report also maybe also.
Is there is not updated. Heard Mr.
M. Alok.
M. Alam, learned counsel for the petitioner, who submits that in respect of the same police station case, a bail application of co-accused is fixed on 18th of August, and he prays for listing this matter along with the said case. What is the case number?
AB 1183.
Within bracket AB 1183/2025. On the other hand, learned additional public prosecutor Mr. K. Das submits that the case diary which is available before the court is not up to date and prays for some more time for producing an updated case diary. Prayer is allowed. Let this case be listed on 18th of August.
Item
Highly
33,
obliged.
Let the matter be taken after some time. Mr. Ezra is a.
You are on interim? Yeah, okay. What is your name?
After some time.
What is your name? Heard Ms. J. Rajkumari submitting on behalf of Mr.
No.
A.
After some.
No. After. Your interim will continue. Heard Ms. On behalf of Mr. S. Bora, learned Mr. B. Sharma, learned additional public prosecutor, on the other hand, submits that though the case diary is available before the court, same is not updated and seeks some time to get an updated case diary. The prayer is allowed. Let this case be listed on 28th of August. The interim order shall continue till next day.
item 34,
Here, FIR, your lordship will find at page 11. Here, main allegation against lordship that accused number 1 and other lordship that accused number 1 was already arrested. I have enclosed his forwarding report also. And the rest of the persons are before your lordship. Main allegation of having sexual intercourse with the victim is against accused number 1. May I read the entire FIR or I may point out that part of it?
No, what is the accusation against you?
Against me, lordship, that they helped the prime accused while kidnapping the girl. That is the allegation.
Okay.
And
This is-
Same car, malad, 4 persons in the car, malad, she was malad, forcefully taken in the car and at about 8 p.m. And subsequently to malad,
What is your submission? Let him, let-
subsequently malad, main accused person committed sexual intercourse. Malad, others were in the car, malad, where she was taken back. Forcefully taken.
And subsequent part, as per my lordship, he was, the others were not there. And in fact, lordship, the, if your lordship sees page 12,
no, but still accusation against you. Suppose 4-person kidnap a girl. One of them commit rape on the, with her.
if your
What is the complicity of other 3?
But regarding that, so lordship may I point out for lordship few things. Lordship may kindly see page 12.
Yes.
Page 12, your lordship will see the down below accused person's names are there. That accused number 1, Anisur Rahman, he was arrested. He is the prime accused in the present case. Other three, that Asraful, Safar and Ainul, they are brothers of the accused number one. Whether it is probable lordship that they will together commit. And other person lordship that Aminul Haq, they are neighbor lordship. They are from different village. And in the forwarding report, if your lordship see page 22. Ground number 3, lordship may kindly see. During investigation, the victim girl stated in her statement that the accused person kidnapped her and took her to Dimakusi village where he kept her there. So it is against that person who was arrested, lordship. Kidnapping and other part lordship against him.
Okay, let us see the case diary.
Recovered and probably further custodial intervention will not be required in the present case.
No, but anticipatory bail, if you have complicity in cases of such nature, if you are not involved, you may get. What is your submission?
Well,
Do
she was kept whole night, raped by the accused number one. And on next day morning, all the persons malat back in that car malat, and she was thrown in the roadside malat. There is there malat. When she was taken, all the persons in the car.
Whether they have lordship knowledge that kidnapping will be there, lordship, that part lordship will see. Lordship. And whether all are brothers, whether it is probable that all will be committed such offense together.
Oh, many things which should not happen are happening.
The present
So,
facts, lordship. The present.
What is your name? Ashraful.
No, Asraful is the prime accused. He was yes, Asraful Haq is there. Lordship. Asraful Haq.
Ashraful Safar. Who are the petitioners?
Ainul Haq, Asraful Haq, Safar Ali, Aminur Haq, Minazul Haq. Page 12, your lordship will get that notice.
Ashraful Safar and Amina. What is the, Mr. Parashar, against Ainul and Minazul? What is there were only 4 persons. Petitioners are 5 in number. Out of those 4, 1 has already been arrested.
Ainul malat. Anand,
Anisur already.
Anisur arrested, yes.
So, what are the materials against Ainul and Minazul? It is not there. If it is not there, they may be allowed to go on bail. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Who is appearing for the victim?
Name here, M. Mondal.
M. Mandal is not before us. Who is appearing for the? Who is appearing for the? Whose name?
So that one.
Who is M. Mandal? Heard Mr. A. Ahmed, learned counsel for the petitioners, Mr. K. Parashar, learned additional public prosecutor. Stop. Though name of Mr. M. Mondal has been shown in the cause list as engaged counsel for respondent number 2, he was not found on call. This application under section 482 of BNSS 2023 has been filed by the petitioners, namely Ainul Haq, alias Ainul Haq, number 2 Ashraful Haq, number 3 Safar Ali, number 4 Aminur Haq, and number 5
My lord, one.
Minazul Haq.
Four names she has taken and Gari Solwajonok Sini Napao. That means 5%. She has taken the name of Anisul, Ashraful, Safar, Amor. Aminur is yes, Aminur. Aminur. Anisul, Ashraful, Safar, and Anisur. Gari Solwajonok Sini Napao. That means 5%.
Now, who is that?
Who is that, my lord?
Is there any material?
FIR 6 persons,
Specifically, my lord, we can-
5 persons before your lordship. One already arrested.
Who are apprehending their arrest in connection with Agomani PS case number 70/2025 under section 140 within bracket 3/127 within bracket 2/3 within bracket 5. Mr. Parashar, while I am dictating, you go on finding out whether their names are there or not. 3 within bracket 5 of BNS, read with section 4 of the POCSO Act. The gist of accusation in this case is that on 4/5/2025, the father of the victim girl had lodged an FIR, naming 6 accused persons therein, including the present petitioners. Inter alia stating that on 2/5/2025, the minor daughter of the informant was kidnapped from his house and Ashraful Haq and
Petitioner number 1,
petitioner number 1, Ainul Haq,
petitioner number 3.
and petitioner number 3, Safar Ali, are the brothers of the main accused Anisur Rahman, and it is unlikelihood that all the brothers would conspire together to commit an offense of such a nature. He also submits that in the meanwhile, the victim girl has also already been recovered, and therefore custodial interrogation of the petitioners may not be necessary.
Forwarding report, your lordship, it is alleged that against the prime accused, all allegations were there. lordship.
He also submits that in the forwarding report of the accused number 1, it is stated that the victim girl has made accusation only against the accused number 1 named in the FIR. Stop. He submits that the petitioners are ready to cooperate in the investigation and therefore prays for allowing them to go on anticipated bail. On the other hand, learned additional public prosecutor, Mr. K. Parashar, has produced the case diary of Agumani PS case number 70/2025 and has vehemently opposed the grant of bail to the petitioners on the ground that the victim girl has implicated the petitioners in her statement recorded under section 183 of BNSS. He also submits that the victim was kidnapped in a four-wheeler vehicle. However, she was unable to identify the driver of the said vehicle, and the investigation in that regard is still on. You could find the name
Ainul and
Minazul.
Minazul.
I have considered the submissions, next para, I have considered the submissions made by learned counsel for both sides and have gone through the case diary of the Agumani PS case number 70/2025. On perusal of the case diary, including the statement of the victim girl recorded under section 183 of BNSS, it appears that the petitioner number 3, 4, petitioner number 2, 3, and 4, namely Ashraful Haq, Safar Ali, and Aminur Haq, have been categorically implicated by the victim girl of having committed the offense alleged in the FIR, though the accusation of physical intercourse is only against the accused number 1. However, the above named petitioners helped, participated in kidnapping of the victim girl. This court is therefore not inclined to pass a favorable order under section 482 of BNSS against the petitioner number 2, Ashraful Haq, number 3, Safar Ali, and number 4, Aminul Haq. Stop. Accordingly, their prayer for anticipatory bail is rejected at this stage. Next para. As regards the petitioner number Ainul Haq and petitioner number 5, Minazul Haq, though their name appears in the FIR, however, the victim girl has not specifically named them of having participated in the offense alleged in the FIR. At the present stage, there appears to be no incriminating material. Present stage of the investigation, there appears to be no incriminating materials against the aforesaid 2 petitioners. So therefore, this court is of considered opinion that if they cooperate in the investigation, their custodial interrogation may not be necessary for fair completion of the investigation. Accordingly, the petitioner number 1, namely Ainul Haq alias Ainul Haq, and petitioner number 5, Minazul Haq, are hereby directed to appear before the investigating officer of Agumani PS case number 70/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, both the above named petitioners shall be allowed to go on bail of ₹30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Condition take from Abhishek. This bail application is accordingly disposed of. Send back the case diary.
Item 35.
You are on interim.
Yes.
It is not be received, no?
Heard Mr. M.U. Mandal, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number stop. On the other hand, learned counsel for the petitioners has submitted that both the petitioners were allowed to go on interim bail by this court on 4/6/2025. And you have appeared,
They appeared.
and in pursuant to the directions of this court, both the petitioners have appeared before the investigating officer and have cooperated in the investigation. Stop. In view of the submissions made by learned counsel for the petitioner, the interim bail granted to the above named petitioners by order dated 4/6/2024 5 is hereby made absolute with condition number 1 attached to the said order remaining intact. This anticipatory bail application is accordingly disposed of.
Item 36.
Develop, please.
Okay.
Item 37.
I was on interim manner. I have already.
Heard Mr. S.H. Sikdar, learned counsel for the petitioner. Also heard Mr. K. Parashar. Also heard Mr. K.K. Das, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed on 28th of August. The interim order shall continue till next day.
Item 38.
May I please, my lord, this is 482 application. This is a subsequent bail application on behalf of the accused petitioner. The earlier one was rejected. My lord, the present accused petitioner is a 65 years old man and he is a retired police officer. And he is suffering from several heart problems. So I urge my lord to take up this matter today. My lord, after considering the matter, if my lord feels that this is not a fit case, then my lord may avoid granting me interim. But
No.
first,
Where is the rejection order?
rejection order, my lord will find at page
CD is not there.
my lord, CD may not be there, but still, my lord may kindly come to page 52. Not page 52.
No.
No, this is not, my lord, by this order, the petitioner's son has been granted bail. My lord may kindly come to page,
Let the case diary come.
no, my lord may kindly consider, my lord, for at least one, kindly come to the FIR in this case, my lord. FIR is a very short one, my lord. FIR is just page 70.
But those things were considered in the earlier bail application.
So, my lord, there are certain documents which I have annexed, my lord. Those documents were not being considered. My lord may kindly come to page 39. This is the order by which my earlier bail petition is rejected.
Yes,
My lord, the main contention by which my bail petition was earlier rejected is that after getting the interim from the Court of Session, I have misused my liberty. My lord, which is absolutely false. Because I have present some documents, my lord may kindly consider that for once. Therefore, I request my lord to kindly come to the FIR for a moment, my lord, which is just page 70. This is the vernacular FIR,
page
17, my lord,
17.
17, my lord.
Yes,
May I read, my lord?
yes.
Yes. বিনীত সন্মানপূৰ্বক নিবেদন সহকাৰে আপোনাক জনাও যে মোৰ নামত থকা এনঅচি নাম্বাৰ so and so নম্বৰৰ এনঅচিখন মই দিলীপ পাল পিতা প্ৰয়াসী মোহন পাল গাঁও উৰাগাঁও থানা মায়ং জিলা মৰিগাঁও লোকজনক বিক্ৰী কৰোঁ। মাই লৰ্ড, দিছ ইজ দি এলিগেশ্যন পাৰ্ট। বৰ্তমান জানিব পোৱা মতে উপৰোক্ত 1 নম্বৰ আসামীজনে মোৰ নামত থকা মাটি কিনা বেচা কৰা এনঅচিখন চক্ৰান্তমূলকভাৱে ইংৰাজীৰ 10/11/2022 তাৰিখে জালিয়াতি কৰি উলিয়াই আনি এডিট কৰি 2 নং আসামীক লগত মাটি কিনা বেচা কৰে। My lord, there are 2 accused in this case. If your lordship, my lord will see that accused number 1 is the Bibha Bora and second one is the Unil Raspa. And this is the petition that has been filed on behalf of Unil Raspa. And if my lord will see that there is no specific allegation against accused number 2, because the allegation is very specific. বৰ্তমান জানিব পোৱাৰ মতে 1 নং আসামীজনে মোৰ নামত থকা মাটি কিনা বেচা কৰাৰ এনঅচিখন চক্ৰান্তমূলকভাৱে ইংৰাজীৰ 10/11/2000 তাৰিখে জালিয়াতি কৰি উলিয়াই নি এডিট কৰি 2 নম্বৰ আসামীক মাটি বিক্ৰী কৰি। So my lord, there is some specific allegation against accused number 1, but there is no allegation against accused number 2. And secondly, my lord, there is no allegation that some plot of land which is originally belonged to the informant has been sold by the accused number 1. Now, my lord may kindly come to page 45. This is an integrated land record management system. I have taken out a copy. My lord will find, my lord may please come to page number 45.
Yes,
My lord will find that one Nirod Bora and Bibha Boras, their name has been registered as legitimate owner of a plot of land.
yes.
Then my lord may kindly come to page 49. This is the order passed by the circle officer. May I read, my lord? Page 49.
Yes,
চক্ৰ বিষয়াৰ 5/9/2000 তাৰিখৰ নামজাৰি নামত so and so হুকুম মৰ্মে 964 নং দাগৰ 2 কঠা মাটি খৰিদাৰী সূত্ৰে নিৰুদ বৰা is the elder brother of the বিভা বৰা লগতে শ্ৰী বিভা বৰা আৰু লগত অনিল ৰাজখোৱা নামত নামজাৰি কৰা হ'ল। Registration deed so and so. My lord, another important factor is that the Mondol was Ranjit Soikia. His name is reflected at the last part. My lord, basically, Nirud Bora, Bibha Bora, and Onil Raspa all are family members. Bibha Bora is the relative.
no, what you want to submit?
I want to the point I want to make is that, my lord, Bibha Bora is a registered owner of a plot of land, and subsequently she has sold her share of land to Unil Raspa. That, my lord,
Only the accusation is that she forged the NOC.
my lord, when she is a legitimate owner of the plot of land, her name is reflected as registered owner, then there is no reason for her to committing any kind
No,
of
but
fraud.
the bail was cancelled, not granted mainly because you misused the bail granted to you by Sessions Court.
Yes, my lord.
What is your submission on that?
No, my lord, I will come to my submission. My lord, may kindly come to page number 50.
Page?
Number 50, the next page.
Yes.
চক্ৰ বিষয়াৰ 27/3/2023 তাৰিখৰ নামজাৰি নাম্বাৰ ইমান হুকুম মৰ্মে 964 দাগৰ 1 কঠা মাটি খৰিদাৰী সূত্ৰে বিভা বৰাৰ লগত অনিল ৰাজখোৱাৰ পিতৃ নুমল ৰাজখোৱাৰ নামত নামজাৰি কৰা। Thereafter, my lord, the Bibha Bora has sold her share of land to the Unil Raspa.
Okay.
Now, my lord, that why somebody has a registered owner of a particular plot of land, there is no reason for her to obtain an NOC by committing some kind of fraud. the reason behind why she has been made accused in this case, that my lord will find on the additional affidavit which I have filed before this order. My lord may kindly come to page 70 of my additional affidavit. By this, my lord, entire thing would get clear. 70. My lord, this is a charge sheet that has been filed before the Chief Judicial Magistrate Nagaon, and the case has been going on before Additional Session Judge number 2, bearing case number TI 25/24. My lord, may kindly come to page 70 for a moment.
70.
70, my lord.
Yes.
The brief history of the case is that on 26/4/2022, complainant Nirod Bora, that means the brother of the Viva Bora, let so and so APS so and so, lodged an affair to the effect that on 25/4/2022 at 1:30 p.m., complainant went to Kanpur Circle Office to meet with Latmandal Ranjit Hazarika. My lord, he is not Ranjit Hazarika, he should be Ranjit Soikia. And during discussions about his land, in the meantime, accused Sri Jugal Rajbanshi came to the circle office and used slang language to him and punched his chest. As a result, he sustained injury on his person and he was shifted to the hospital for treatment. Hence, a case has been registered by Kanpur PS case so and so. My lord, the second line is very important. During the treatment of the complainant, Nirod Bora was expired. Now, my lord, in this case, Viva Bora is the accused number 1. That, my lord, will find at page 68. My lord, may kindly come to page 68, my lord. If my lord see the witness column, then Viva Bora is the witness number 1, who has been cited as a charge-sheeted witness, and Ranjit Soikia, who happened to be the Latmandal. Because Nirud Bora went to the Latmandal office to meet Ranjit Soikia, and before him, my lord, he was killed. So, my lord, the present affair has been filed more specifically against Viva Bora, so that I could give a diluted testimony in this particular case, so that the main accused in this case would get the benefit of
Who is the accused
in this case, my lord.
in the
In
charge
this,
sheet which you have shown?
my lord, one Jugal Rajbanshi.
How he is connected with this case?
My lord, he directly may not be connected, my lord, but it is an implied thing, my lord.
How?
Because, my
you
lord,
have to show how it is implied.
no, my lord, everything cannot be shown. My lord, there are certain
Then what
things,
is your submission?
my lord, there are certain
There
things.
is a case pending
Yes, my lord.
against Viva Bora.
Yes, my lord.
That itself does not make your case strong.
My lord, but there is
Unless you
allegation against me, my lord, in the affair. Because entire allegation is against Viva Bora in that particular case.
but
what is
the judicial order of Sessions Court,
Yes, my lord.
where it was observed that you misused your liberty
My lord,
by
I never misuse my liberty, my lord. I am myself is a police officer, my lord.
no, but you have not challenged that observation.
My lord, I may not be directly challenged because this is not an appeal or a revision petition which I am prepared. This is only bail petition, my lord. But I have brought all the materials, my lord, by which there is a clear indication that a false affair has been lodged against Viva Bora as well as against Unil Raswa. Because the very purpose of lodging this affair is to trap Viva Bora to an extent that so that she gives a diluted testimony in this particular case, which is going on before the additional session judge number
But
2.
how it is linked? How the present informant is interested in getting a diluted testimony?
No, because my lord, if my lord see,
No, unless you show that link,
no, my lord,
your submission,
everything cannot be shown, my lord.
then your submission falls flat. Because unless you connect that
I may not
the
have my lord direct material to connect, but my lord may kindly come to.
your submission must have some basis.
Yes, my lord.
Merely Viva Bora is shown as a witness
Yes.
in a pending case.
Yes.
Your submission is therefore Viva Bora has been named as an accused in this case.
In this case, my lord.
But what
And
is
I
the
have been
interest?
scapegoat, my lord.
But
There
what is
no
the
allegation against me otherwise in the affair? Allegation is only to the extent that that particular land has been sold by the Viva Bora to the Unil Raspa. This is the only allegation against me, my lord.
Yes.
So considering that, my lord, interim may be kindly granted at this time. This is my humble prayer.
Rejection on the there are two for one is that there are clear evidence to show that he is involved in the forgery. Second is also
How he misused his liberty? Page number? No, is there any indication? Yes.
My lord, this is the paragraph. I have perused the case. All right.
I have produced the case diary along with the material collected by the IO. I have also gone to the file considered the other committee to see that the present issue appears to have been involved in the land transaction immediately by manufacturing documents. And there are clear evidence to show there was practice of fraud and forgery being committed by the present issue along with the others who are mainly his family members. There is also material indication to show that the accused has misused the benefit of interim protection given to the high order dated 25/4/25 and appears to have approached the complainant and tried to influence the investigation. There appears serious education and with the other political person in the present position to influence the witness.
But my lord, one thing I would like to point out. My lord, in present time, where everything has been computerized, my lord, there may be possible that I could commit forgery of one particular document. But I have seen, my lord, integrated land record management system. Everything cannot be manipulated by me, my lord. If it is a matter of one particular document, it is altogether a different thing. Because there is no dispute that Bibha Bora is the registered owner of the particular plot of land, and she has every
Okay.
right to alienate the property in whoever's favors she has desired. My lord, considering that, my lord,
Where is Vibhavara? Has she been arrested?
my lord, she has been arrested in this case, and subsequently she has been granted bail. She has been arrested, my lord.
When can you produce the case?
My lord, till then, my lord, he's a 65-year old. My lord, I have annexed certain documents. My lord, till date.
No, to appreciate your submission,
Yeah.
unless we peruse the case diary, things remain where it was earlier till the reject. We may appreciate your submission, but only after perusal of the case diary. Heard Mr. B.K. Deka. Heard Mr. B. Deka, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for production of the case diary. On the other hand, learned counsel for the petitioner submits that the accusation against the petitioner, accusation in the FIR has been made mainly against the co-accused Biba Bora, and the petitioner has only purchased the share of land of which Biba Bora was the owner, and no specific accusation has been made against him in the FIR. He also submits that the petitioner is a 65 years old person and is ready to cooperate in the investigation, and therefore prays for interim protection till arrival of the case diary. Stop. I have considered the submissions made by learned counsel for both sides. Stop. As the earlier bail application of the petitioner was rejected after perusal of the case diary. Hence, even to appreciate the submissions made by learned counsel for the petitioner at this stage, perusal of the case diary would be necessary. Hence, call for the same. List this matter when
My lord, on 12th.
on 12th.
Item 39.
The lordship, may please, your lordship, matter may be withdrawn. I have the instruction from the court.
Heard Mr.
So the
S. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Mr. B. Sharma, learned additional public prosecutor. As well as Mr. What is your name?
Mr. Sheikh, but my lord, I have not yet filed the Galatama. I'm going to find the Galatama.
Okay, you need not to file.
On instruction, due instruction, I am happy.
Heard Mr. T. Sheikh, who appears for the informant. Learned counsel for the petitioner prays for allowing the petitioner to withdraw the instant anticipatory bail application. Stop, the prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Item 40.
Lordship, Amicus may be appointed, lordship.
may I please,
Who is the amicus?
Has not been appointed as of yet.
Notice has been served.
My lordship, this is.
Heard Mr. S. B. Laskar, learned counsel for the petitioner. Also heard Mr. D.P. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the notice issued to respondent number 2 has been duly served as informed to him by the officer in charge of the jurisdictional police station. Stop. Since no one has appeared for the petitioner in this case, the court intends to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Ms. M.K. Brown is appointed as amicus curiae to defend the cause of the respondent number 2 in this case. The petitioner shall furnish a copy of bail application along with annexures to the newly appointed amicus curiae today itself during the course of the day. The registry shall reflect the name of Ms. M.K. Brown as amicus curiae for respondent number 2 in the cause list henceforth. When? Yes. Eighteenth.
This ordered, my lordship, teacher, my lordship.
You
Actually, my
suggest I am asking when?
Speak.
Next week? Well, list this matter again on 12th of August.
Highly appreciated.
Move orders, item 42.
may please, your lordship. And here appellant is convicted under section 304B.
There is an office notice
for 8 years. Well,
office notice, notice has not been served, lordship, probably.
but it is not the case.
Foxo is there.
So, well,
304B.
304B IPC. So, when here, though, informant also may be hard.
Respondent number 2 is there.
As per new notification. Why do you have filed?
What is the offense?
304B, lordship, dowry debt.
Respondent has to be heard.
Yes. They have included the respondent number 2, lordship.
As per new notification.
Which
POCSO case
notification?
matter. For POCSO case. The informant is.
No, you have made them a party and the notice has led.
We have filed it is last year, so that time it was a order of the court, my lord. but subsequently I've forgotten that notification, but in some cases,
Heard Mr. Ainuddin Leonard. Why this is fixed in orders column today? Because of the, this notice, okay. Heard Mr. Ainuddin Leonard Counsel for the appellant. Also heard Mr. B. Sharma, Leonard Counsel, Leonard Additional Public Prosecutor, appearing for the state of Assam.
because maybe
No, let us get a report.
we have taken steps also.
What is the accusation? Yeah. How much is the punishment?
Punishment is here is 8 years. And my lord, already 1 year, 2 months, 18 days today. And in fact, case is case is acquittal now, as per my observation, my lord, because 304B is not ingredient. Ingredient is not available in here. my lord. Though the landed passengers convicted him. He committed suicide by hanging. And my lord, no suicide note. And my lord, no prior any complaint. And no, neither was examined, my lord. And my lord,
3 months of marriage.
yes, my lord, she committed suicide, my lord. And
Presumption is always
medical history also, my lord,
It appears from the office note that the trial court records have already been received. However, the notice issued to, however, there is no report of service as regards notice issued to respondent number 2. Yes, suggest, Mr. What is it?
We should wait for the notice first.
ultimately, my lord,
The registry is directed to verify from the track consignment report as to, of the notice sent to respondent number 2 as to whether as regards the fate of the said notice and put up an appropriate office note to that effect on the next date fixed. Let this case be listed on 18th, 18/8.
I am.
Item 40 and 44.
Before starting by my understanding, Lordship, in this case, we have been engaged with Mr. P. Kotogi and myself also, and been appointed as a special public prosecutor recently, Lordship. And in both cases, Lordship, we have seen that objection against the bail payer has not been filed. So we'll be filing, Lordship,
How much is the punishment?
10 years, Lordship,
10 years.
10 years. So, Lordship, matter may be taken up immediately after 10 days, Lordship, we'll file.
Let them file objection.
Lordship, on the previous 2 dates, Lordship, it was made the consideration that it should be the last date, but they have engaged newly, so we don't have an objection, but a date may be fixed, Lordship. And there must be an observation that if they fail to file the objection, because already Lordship.
Then what the court should do? Tell me. Then
Say an observation should be made,
what observation suggest?
if they fail to, Lordship.
Then what?
Then as per law, Lordship,
Otherwise, it will not be as per law.
on the merit of the case that. Lordship.
Heard Mr. What is your name?
Amen.
Heard Mr. A. Mena. This is item number? Item number 43. Heard Mr. A. Mena. IARO Criminal Appeal of Common Order. Also heard Mr.
I'm PP Doctor,
BP Datta,
special public.
Learned Additional Special Public Prosecutor.
Item number 44, PD.
No, just a minute. Both these cases arise out of common judgment,
Common judge,
common order. Also heard Mr. What is the name?
PD.
P.D. Bhuya, learned counsel, appearing in criminal appeal number 324/2024. Mr. Mena appears for criminal appeal number 215/2020. Also heard Mr. P.P. Dutta, learned additional special public prosecutor, CM Vigilance Cell.
It's not CM.
It is, it is,
Normal.
oh, learned, sorry. Learned special additional public prosecutor, who submits that they have been newly engaged in this case and state intend to file a written objection against the interlocutory application filed by the petitioner, filed by the appellant seeking suspension of the sentence during the pendency of the connected appeal, hence, he prays for 10 days time for filing written objection. The prayer is allowed. Let this case be listed again on 21/8. List accordingly.
I have a pair that it may be directed to reflect the name of P. Kotoki and P.P. Dutta.
The registry is hereby directed to reflect the names of Mr. P. Kotoki as special public prosecutor, as well as Mr. P.P. Dutta as additional public prosecutor.
If it will be 20, it will, if possible, 20 August.
20.
20.
Okay. Let it be on 20. List accordingly.
I did 45.
There's an application for suspension of sentence. State has submitted their objection.
What is the offense?
76 lordship, sentence of 10 years. Our basic ground is 4 ground lordship. There is an unexplained delay in filing the FIR. It is after 5 months it was filed. Material contradiction is there, but IO was not examined.
No, but these are to be examined.
But submission lordship, if it can be examined, it will show that there is a chance of acquittal. And if there is a chance of acquittal, perhaps sentence may be suspended in that way.
Malad prima facie, Malad, if Malad go through only the statement of the PW1, the victim Malad, the inner statement in the PW1, he stated that he has committed rape by this person and at that night when she was sleeping. And FIR was lost out of fear because when she became pregnant, after 5 months, FIR was lost. That explanation is there in her statement also.
It is inside.
Yes, after the judgment around not yet completed. After the judgment not yet completed 1 year. Judgment of 13/9/2024.
Inside a house lordship, no persons from the house was examined. Of course, it is accused person's house. There were his daughters, his wife, his son, child. And she was staying there for 15 days.
I am going for respondent number 2, my lord, informant, father, my lord. It's a very after going through the evidence on record, your lordship will find that there are sufficient materials against the accused person, my lord. 76 conviction, the sufficient materials, my lord, so at this stage, my lord.
I have not completed my submission.
No, what I was thinking, now whether in the IA an observation can be made that there are, while rejecting that there are sufficient materials, unless it is a clear case.
Clear case of
It is not a clear case.
There is a contradiction if I can show lordship. material contradictions. These when IO was not examined by the learned trial court. So a prejudice has been caused to the accused. Material contradiction regarding this entire episode. And when he filed, her father examined his PW3 at page 33 of my
Okay, your first ground is delay.
delay lawsuit,
How much delay
5 months delay. And
in lodging the FIR?
in lodging the FIR.
Second ground,
Second ground, IO was not examined despite the material contradiction. There is a prejudice has been caused to the accused. And the allegation that place of occurrence is the house of the appellant accused. He was a relative. In that house, his wife, his daughter, who is at the same age of the victim. His son was staying, and they were all around in the house. None has been examined as a witness. And she was staying for 15 days there. And her father says in his deposition that when they scolded her, she took the name of the. So this is another aspect.
anything else?
Now, contradiction lordship, PW1, I have annexed as page 23. I'm just reading what is the contradiction part, which could not be confronted with the IO. As page 24, it is there. It is not a fact that I did not state before the police that before 3-4 days of the incident, I went to visit the house of our one relative at Dibrugarh. At the time the accused and my cousin sister called me to their house. On their request, I came to Tinsukia. On my arrival, my cousin sister received me at Tinsukia bus stand. On coming to their house on the same day at night, I slept with the minor son of the accused. There was no door in the room. At night, the accused left the room. Then accused came to my sleeping room and asked resisting. And when I told the accused not to subject, otherwise.
Prima facie is the case of because in that case, will can be granted very sufficient and if half of the punishment already undergone. Now, the prisoner is beyond the bar because of the discussion. So the certain notice earlier and
Which judgment?
non-examination of the IO needs to be and the victim of the case as well as the evidence being used during the course of trial. In order to infer whether it is what to lead to the the minor child of the subsequently the son video and the same and getting him out to committed there. This case, because the going it can be the prima facie it is of the case for the citizen. Then and in the there is not computer.
Okay.
In both the
If lordship case is that
Yes.
To get by get my mouth by his hand and raped me, and after he left the room.
This
Page
is
number
contradiction.
23, my lord. Page number 23,
I
last
was
line.
not been examined.
And 164 statement also recorded, my lord.
In 164, she said similarly. In this,
Madam, search memo also, search it also same. আসামি ঘৰত কোনো গম নোপোৱাকৈ তাইৰ সৈতে বলপূৰ্বক শাৰীৰিক সম্পৰ্ক স্থাপন কৰিছিল, ফলস্বৰূপে নিৰ্যাতিত ছোৱালী ৰিয়া বৰ্মা 5 মহীয়া অন্তঃসত্ত্বা হৈছিল। পেজ নম্বৰ মাইলত 21. So মাইলত হামন submission.
okay, heard Mr. S.D. Purka as the learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, as well as Miss P.B. Bordoloi, learned legal aid counsel appearing for the respondent. Number 2. This application under section 430 of BNSS 2023 has been filed by the applicant, Shri Uttam Das, praying for suspension of sentence during the pendency of the connected appeal number, connected criminal appeal number 349/2024, as well as praying for bail of the present petitioner, present applicant. Stop. The applicant was convicted under section 376 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000, and in default of payment of fine to undergo further simple imprisonment for 6 months by the Court of Learned Additional Session Judge within bracket FTC number 2 bracket close, Tinsukia, in sessions case number 13 within bracket T of you, both of you may take your seats. 13 within bracket T of 2020. Next para. Where is the FIR?
Page 14, lordship. I feel number. Vernacular is 15.
The next para. On 29/5/2019, the father of the victim girl had lodged an FIR before the officer in charge of Tinsukia police station, inter alia alleging that it is because of the present petitioner who had cohabited with her minor daughter, she became pregnant and was carrying pregnancy of 5 months at the time of lodging of the FIR. On the basis of the said FIR, the investigation was initiated and ultimately charge sheet was laid against the present applicant, against the above named applicant. Stop. During and after lodging of the after laying of the charge sheet the charges under section 376 of IPC. Charge under section 376 of IPC was framed against the present applicant. When said charge were read over and explained to him, he declined to plead guilty and claimed to be tried. During trial, how many witnesses? During trial, 6.
No, to the four doors. Four. Four witnesses.
4 prosecution witnesses were examined by the prosecution side to bring home the charge against the applicant. Stop. The applicant was examined under section 313 of the applicant was examined after completion of prosecution witnesses, during which he denied the truthfulness of the prosecution witnesses and pleaded his innocence. However, no defense evidence was adduced by the defense side. Ultimately, by the judgment dated 13/9/2024, passed by the learned additional session judge in sessions case number 13 within bracket T/2021, the applicant was convicted and sentenced in the manner as already described in the foregoing paragraphs. Stop. The applicant has impugned the aforesaid judgment by filing the connected criminal appeal, that is criminal appeal number 349/2024, which is pending before this court. Learned counsel for the applicant has submitted that the petitioner, that the applicant is innocent and has been falsely implicated in this case. He submits that there is every likelihood of the connected appeal filed by the applicant resulting in a favorable order of acquittal, and therefore during pendency of the connected appeal, he prays for suspension of the sentence imposed on him and allowing him to go on bail. He submits that in this case, there has been an unexplained delay of 5 months in lodging of the FIR, which itself shows the falsity of the accusation made against the present petitioner. Stop. Present applicant. Stop. He also submits that in this case, the applicant, he also submits that during the trial, the applicant was also deprived of confronting the contradiction of prime witnesses to the investigating officer, as the investigating officer was not examined as a prosecution witness by the prosecution side. He submits that on that count, he is entitled to get benefit. Stop. He also submits that though the place where the alleged offense was committed was the house of the present applicant, where the family members, where his family members were present when the alleged offense was committed, like his, who were present?
Daughter,
Like his wife, daughter and son, comma, however, none of them were examined as prosecution witness in the trial. What else is, he also submits that the FIR does not make any direct accusation of rape on the present applicant. He submits that in the evidence, it would be, from the evidence, it is apparent that the victim named the applicant only when she was scolded by her father, that is the informant. And therefore, there is a doubt as to whether she was deposing truly before the trial court or not. He therefore submits that there is every possibility of the applicant getting a favorable order in the connected appeal, and thus, and therefore prays for suspension of the sentence during the pendency of the said appeal, and also prays for bail. Stop. On the other hand, learned additional public prosecutor Mr. K.K. Parashar, as well as learned legal aid counsel representing the respondent number 2, Mrs. P.B. Bordole, have vehemently opposed the prayer made in the interlocutory application by the applicant. They submit that in this case, the victim has categorically implicated the applicant of subjecting her to forceful sexual intercourse. Learned additional public prosecutor also submits that merely because the investigating officer has not been examined may not be a ground for discarding the testimony of other witnesses if same are otherwise reliable. In support of his submission, he also cited the apex. He also submits that there are rulings of the apex court in this regard, which he intend to rely during the hearing of the main appeal. He also submits that this is not a case where there is no evidence and prima facie it appears, and prima facie the petitioner appears to be innocent. Rather, in this case, clear accusation, rather in this case, the victim girl has categorically implicated, and the trial court has relied the testimony of victim girl in coming to the finding of guilt of the present applicant. Learned counsel for the respondent number 2, as well as learned additional public prosecutor, also submits that the applicant has been sentenced to undergo rigorous imprisonment for 10 years And this is not a case where he has already completed half of the punishment imposed on him. Rather, he has been detained behind the bars only since 13th of September 2025, 2024, which is even less than a year. They therefore consider, both the council therefore pray for, both the council have therefore submitted that the interlocutory application filed by the applicant may be dismissed. I have considered the submissions made by learned counsel for both sides and have gone through the records of trial court which were requisitioned in connection with this case. While considering an application under section 430 of BNSS for suspension of sentence during the pendency of the connected criminal appeal, this court is not supposed to go into depth of the case and come to the finding of guilt or otherwise by examining the materials on record meticulously while disposing of the interlocutory application stuff. If prima facie this court comes to a finding, if prima facie from the materials available on record, this court comes to a finding that the petitioner has a good case in the appeal, there may be ground for suspending the sentence imposed on him. However, in the instant case, considering the fact that the victim girl has specifically implicated an officer, is a question to be decided in appeal after full hearing. Said question may not be decided in this interlocutory application, as any decision on the said question, either in affirmative or in negative, would have a bearing on the pending appeal itself. This court is therefore of the considered opinion that this is not a case where the sentence imposed on the petition applicant may be suspended during the pendency of the connected appeal. Stop. The applicant may, however, however, would be at liberty to file a separate application for praying for expeditious hearing of the connected appeal. For the aforesaid reasons, this interlocutory application is dismissed. Anything?
Number 36, pending matter, taken up on the Friday.
36 on Friday on request.
Interim to continue.
on request of Learned Council.
And CD may be.
The matter may be listed on Friday. The case diary may be retained till next week.
Okay.
Volume order. Order on this item number 1.
For reasons mentioned in the order, the prayer for bail of the petitioner is rejected at this stage.
Daily list item 3.
Actually, I need some, how you are connected to the driver? Why you gave 15,000?
Transferred to the owner of the truck at the behest of the owner of the truck by my husband. I am not associated. My bank account was used. My lord. It is not me who has transferred. My bank account was used, and therefore it is reflected in my bank account at the behest of the owner of the truck, not the driver. I, the petitioner, personally do not know the truck driver, neither do I have any connection with the truck driver. There is absolutely nothing in the final report also to show that I am connected to the truck driver.
Your main submission is that she gave the money for daily expenses to the driver, 15,000. And her account was used for paying 2 lakhs. 2 lakhs by husband only.
6 months prior.
But husband has been discharged.
His statement, 67 statement of the driver, he has stated that I got this money from Bapi Devna, not from the petitioner or from anyone else. It is mentioned in the
That 15,000?
It is mentioned that I received it from Bapi Devna. That is, I'll just read out the relevant paragraph.
Mr. KL, you want to say something?
Again, paragraph 3 of my objection. We have given the bank statement of. If the question will arise, how a person will allow his account to be used by some other person?
Yes.
Your Lordship, may kindly come to page number 32, Your Lordship. Page number 32, Your Lordship, of the petition in paragraph number C, Your Lordship. Page number 32, paragraph number C. This is the statement of the driver, Your Lordship. May I read the statement, Your Lordship?
No, okay. Paragraph number C. Page 32 is the complaint, part of it. Complaint.
There it's been mentioned, Your Lordship, from one Mr. Devnath, Your Lordship.
Yes, what?
I read the relevant paragraph, Your Lordship. He also stated that the truck needed some minor body repair work, for which he was instructed to take the truck to Bishnujyoti Bodybuilders near Nilachal Parking, Lalmati. Accordingly, he started from Umlang in 9/9/2022, early morning, and entered Bishnujyoti Builders at around 7 a.m. in the morning. He received rupees 15,000 from one Mr. Devnath on 10/9/2022 for both repair expenses and his commission for transporting the ganja concealed in the secret cavity of the said truck. The said amount was received by him through one Miss Pandit Traders, Almaty, Guwahati via Google Pay. The proprietor of Pandit Traders gave him the said amount in cash, Your Lordship. So this is the entire setup, Your Lordship. That in this statement, there is no relevance with regard to the current petitioner, Your Lordship. It is my husband's, but this Devnath is also not my husband, Your Lordship. And that cash was given to him by another computer shop owner, Your Lordship. And that computer shop owner is not a part of the accused list, Your Lordship.
No, Google Pay can be used by the owner only, by the person in who.
This is my husband, Your Lordship. Husband will definitely have access to the, and this is at the behest of the owner of the truck, Your Lordship, not to the driver directly, Your Lordship. And the same money which was 2 lakhs 6 months prior, same at the behest of the owner, Your Lordship. I am not in nowhere connected to the driver, Your Lordship. Not even one single instance of connectivity, Your Lordship.
Okay, I'll go through and pass orders. Chamber.
Item 8, 9, 22 and 23.
AC to the deep.
Item 8.
But my learned friend has the CD. Your worship has already seen the malware FIR. The allegations are primarily that some gaming and betting materials were found in 3 hotel rooms. I mean, the 3 rooms of the resort. And the 3 persons, my lord, they were apprehended. And out of the 2 petitioners before your worship, the petitioner number 2, Srimati Jyoti Sharma, she is an employee of the resort, entrusted with the duty of overlooking the cleanliness. And the petitioner number 1, Abhishek Sharma, he has no relation except that, my lord, he goes to pick up and drop his wife. So he is not related with the resort. And the police tried to show that, my lord, he is the owner of the one of the owners of the resort. That is not a fact. And all the materials were recovered from the rooms the persons were occupying. And we have next materials to show, my lord, that they booked it and their identities were verified. And on the basis of those my lord, identities, the payment have been made, my lord, online. All those documents, my lord, I have annexed. Therefore, my lord, my prayer before your lordship is that, my lord, already your lordship rejected on the earlier occasion on the ground that
Where is the rejection order?
rejection order, your lordship will find there are 2 petitions filed, page 56 is one. The operative part, your lordship will find at paragraph 19, page 60. On perusal of the case diary, it appears that the petitioner, who is the husband of one of the co-accused, is not an employee of the club, Nirvan Resort. However, the statement of witnesses recorded under section 180 of the BNSS shows that the above named petitioner used to indulge himself in the affairs of the resort. The statement of witness recorded under section 180 shows that the petitioner is a relative of the owner of the resort and had active role in facilitating commission of alleged offense by the co-accused person. As regards the accusation under section 183 is concerned, the investigation is still at the initial stage and 5 victim girls are yet to be examined by the investigating officer. In fact, my lord, they were arrested on 16th of July and this petition was moved on 23rd of July when your lordship rejected it. The other petition, rejection order, is at page 62 regarding the wife, Jyoti Sharma, and the operative part is at page 67, paragraph 22. The investigation of this case is at a very initial stage and the prime accused, that is the owner of the club, is still evading from police and has not cooperated in the investigation. Moreover, the statement of 5 other victim girls are yet to be recorded. So, my lord, on this ground that it was at the initial stage, your lordship was pleased to reject it. Now, my lord, 20 days have passed by. And we have also annexed the documents of the ailment of the petitioner number 2. And since the petitioner number 1 is not connected, my lord, only some witness makes a statement that I am connected with the relative of the owner. And that is the reason why my wife has got a job there. That may be the reason. But that does not show, my lord, that I can get involved in the activities. And what is the activity, my lord, alleged is that, my lord, some persons who booked the hotel rooms, they were occupying and in their room, these gaming and betting materials were found. And some alcohol.
Apart from that, of accusation under 143 is also there.
Yes, my lord, that accusation your lordship will see from the case diary, because, my lord, they have no role to play, my. And whatever the, my lord, the borders in the hotel are concerned, my lord, whatever is in their possession, my lord, the owner of the, or the manager or any other person of the hotel, my lord, does not have any control over that, my lord. What documents, the materials they carry in their boxes and keeps in their rooms, that, my lord, that responsibility cannot be fixed upon the person, upon the, my lord, other persons.
Yes.
My humble submission is that, my lord, 20 days have passed by, my lord. Today is the 20th day. And the investigation also has been completed by then. And, my lord, the question is, my lord, whether custody retention of, my lord, the detention of these two persons are necessary. That is the.
Okay, Mr. Sharma.
Lordship, here, on the merits, Lordship, I have nothing much to add on, Lordship. It has already been taken care of by your Lordship. But in any case, Lordship, I would like to just read one paragraph in paragraph 21 at page 66. The petitioner has read out the paragraph number 22, but 21 is more relevant, Lordship. Just to illustrate, Lordship, the materials in the case diary. Paragraph 21, Lordship, at page 66.
Yes.
There are materials in the case diary which indicates the complicity of the owner of the club Nirvana Resort, namely Pawan Kumar Sharma, in the LS offence under 143 BNSS and the various provision of the Assam's Games and Betting Act so-and-so. One of the victim girls whose statement has been recorded under 183 of BNSS has categorically implicated the owners so-and-so of sexually exploiting her. She has also implicated the present petitioner regarding her role in appointment of 5 other girls in the club Nirvana Resorts, who were also sexually exploited by the guests of the said resort in lieu of money. Now, Lordship, regarding the other petitioner also, Lordship has held that he also used to take part in the affairs of the resort, and so his bail was also rejected. Now, here, Lordship, the development that is there now, Lordship, 2 more girls have been identified and their statement under 183 have been recorded. I have flagged marked those in the case diary, Lordship. And these 2 victims also, Lordship, they have implicated each and every one of them. In fact, Lordship, if I may just point out just one aspect, one of the victim girls, Lordship, I will not take the name, Lordship, I have marked it. She has stated that she was threatened. What has happened, Lordship, she was asked to cater to the sexual needs of the 4 persons, Mizo persons, Lordship. When she entered the room, Lordship, she for some reason, Lordship, rejected. She did not want to comply with the demand of the guest, Lordship. So she left the resort. And thereafter, Lordship, she was threatened over telephone, Lordship, by owners of the resort. That is the categorical statement of one of the victim girls, Lordship.
And the submission that 20 days have.
Yes, coming to that, Lordship, what has happened, Lordship? Some more girls are there, victim girls. More girls are more victim girls are yet to be examined, and Lordship, it is also the apprehension that some girls may be minors also, Lordship. It is also under consideration, under investigation. And Lordship, regarding the gambling part, Lordship, should I submit on that, Lordship?
Yes.
Yeah, the gambling part, Lordship, some names have come up. Their CDR analysis has been done. Their location was supposed to be tracked down, Lordship, but in the meantime, they have switched off their mobile phones. And these persons, Lordship, are very powerful persons, Lordship, wealthy persons, and of different states, not only of the Northeast, Lordship, they are from all over India, Lordship. Their names have come up. They are actively.
No, regarding role of the present petitioners.
Yes, Lordship, they are.
In offense under 143. Additional materials have come.
Stated 2 girls have been examined, which I have already stated. They have also implicated the present petitioner. And Lordship, regarding the threatening part is also there.
Now, why do you need their further custodial?
Lordship, because of the threat to the examined girls as well as the girls who are yet to be examined, including they might be minor also, Lordship. And this happens to be a sex racket, Lordship, that is going on. And Lordship will kindly see that the gambling was the whole planning, Lordship. It was done over a few days, Lordship. And these girls' statement, if Lordship kindly sees, they were actively, Lordship, threatened to cater to the needs of the guests as well, Lordship. So it was done by the owner themselves, Lordship. And
that is the submission as regards these two petitioners are concerned in 8 and 9. So at this stage, Lordship, if they are released, because Lordship will also see one of the girls at the earlier stage when one of the victim girls was examined, Lordship, she had disclosed that she was threatened over telephone also, Lordship. That apart, Lordship, the main accused of the case is yet to be arrested, Lordship. He is still absconding. So considering the fact, Lordship.
Okay, you give me the case diary.
Yes. After the
If I may add one sentence, my lord, whatever I gather from the submission of my learned friend is that, my lord, the allegation is that, my lord, the owner of the, my lord, the resort, he is involved in all this. And that, my lord, there has been threat. He doesn't say, my lord, the girl who has made a statement, he has been threatened by whom? That your lordship will find in the case.
I'll go through the case. I'll pass orders in chambers to date. Who is assisting you? Are going. Yes, who are you?
This manager of the, club law.
Deepak Saikya. What is your submission?
United part lottery. And regarding the government betting part lottery, that all has been seized lottery and that for the punishment lottery.
And regarding 143 accusation?
I have heard lottery that it was not forceful lottery. She did not like it, she went away lottery. No compulsion was there lottery, nothing has been pressurized.
I have gone through the case diary. There are materials against.
But it made the submission lottery. It says that the girl went to the room, but she did not like it, she came away lottery. That means that is not forceful, they have not compulsion is not there lottery. That part lottery willingly someone is does as per the allegation I am saying, I am not aware of the fact. Because it is if somebody has done lottery as per the allegation, that it might be willingly lottery. Otherwise, lottery is not forceful or compulsion is there from that part lottery. Because she could not run.
Okay, I'll find out from case diary whether there was any exploitation or whether it was consensual.
Forceful lottery to do the act lottery.
Okay.
As per his submission, it reveals that it was not forceful or either lottery that some pressure being used.
Okay. Yes, Mr.
Regarding I am employee of that club lottery and that my part lottery, what I was given lottery, I have done it. Still, that is my part. And regarding that gammon betting part lottery, the punishment is maximum 3 years and already 20 days behind the part. I am not the owner of that part, just the employee lottery.
Yes, Mr.
Lordship, coming to the manager, Lordship, the initial investigation when it was conducted, Lordship, all the evidence regarding the 143 section, Lordship, regarding the girls, those were recovered from his mobile phone, Lordship. Just to clarify, Lordship, I had already pointed out that thereafter, Lordship, the investigation progressed and the girls could have been identified. And Lordship, from their statement also, Lordship, everyone has pointed their fingers at the manager also. He acted as the intermediary, Lordship, of getting the girls. They are calling them. He is also related equally, Lordship, as the owners of the resort.
If something would be there, then FIR would be result in earlier part lottery with some forceful or some that done in the part of 143 lottery. Some victim might have lost earlier lottery FIR against him.
All those things have been taken care of by the Lordship, and the two girls that have been identified, Lordship will kindly peruse this statement under 183. It will make everything clear, Lordship, regarding him also.
Okay. Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. List this matter for delivery of orders on 6th of day after tomorrow.
Much obliged.
Earlier case also day after tomorrow. Let us hear.
Much obliged, your lordship. Much.
अगो केस तो डे आफ्टर पहले वाला केस भी 6
Item 22.
The submissions are already made on the other day, but only for,
who are you?
my lord, I am one of the, my lord, those four, Mizo, my lord, boys, my lord, they were arrested. Now the, your lordship will find nothing was recovered from the petitioner. The initially, my lord, the seizure was made. and
Joseph.
Thereafter only, my lord, I am my lord Joseph Lalpar Mavia.
Yes.
So you will find the seizure list, my lord, at page 44.
In which room you were staying?
8, but on that day I have checked out. I was not there as an inmate, my lord, of that room, my lord. While my lord, this seizure everything was done.
Okay, before the search operation, you checked out of the. Is it your submission? What else is your submission?
So therefore, my lord, the seizure list, what, like the point out once again, my lord, page 44. There's a specific allegation against the, the 3 person under, from home. The materials have been recovered or from the rooms.
Yeah, are you named in the FIR?
Been named.
What is the accusation?
Find the FIR is at page 15, 11, page 20. Page 20, the last paragraph that you may see, the search was started at 10:30 AM under the leadership of the office. So in charge Sonapur PS SCP Sonapur in the presence of the above witnesses during the search of room number 1, 3 and 8 on first floor of the old building of the club Niberna, following individuals were found. Lal Sima, then Lal Pakaroma, then Laringata, then my name is there.
No, but you are saying that you checked out.
Checked out, this, this seizure list should say otherwise, my name would have been there, madam. Seizure list specifically, the 3 persons' name has been.
Okay, your submission is that though your name is there in the FIR, seizure list does not indicate.
At the inmate of the room. These 2 persons, from whom the things are therefore,
Okay,
so far as the, there in the FIR, so far as the allegation of 143 is concerned, it is only kind of the conspiracy element has been given, nothing more than that. Page 23 it would appear. It has been found that the page 23. It has been found that the above them accused persons in collusion with the owners and management of Club Niberna Resort have been involved in running illegal gambling activities for their wrongful gain. The 4 accused persons from Mizoram were being provided shelter and the necessary facilities by the club authorities to carry out these unlawful activities, which include the consumption of alcohol, tobacco, and other criminal acts such as human trafficking. This much only. Then in the forwarding report, if your lordship looks into page 25. Page 25 from 9th line from the bottom. Sentence starts with after verbal. Assam will stop after verbal instruction from the officer in charge to take legal action in case of recovery of any illegal gambling materials and during the search that began at 10:30 under the supervision of officer in charge and SCP Sunapa and police team recovered the following room from following rooms 1, 3, 8 of resort old building number so and so. And then my lord will find page 26. The first paragraph, my lord, the 9th line from bottom.
starts from Nagaon. All the four accused were brought to the police station for interrogation, during which it was found that the four accused persons from Mizoram were being provided shelter and other facilities by the resort authorities for conducting illegal gambling, along with consumption of alcohol and tobacco, and were also suspected of involvement in human trafficking. These are merely suspected. To attract 143, first of all, the procurement has to be there by either of these persons, at least this petitioner. Thereafter, this forceful act to whatever exploitation, etc., been there. That has to come. Now, this petitioner, he had just recently married in 2023 and annexed the marriage certificate as well. And the baby child has been born in 2024. The female girl child about 1 year old, and he is serving as a secretary of a school. Apart from in 2024, he has undergone a heart surgery. Considering this in the earlier order, Lordship has provided the jail authority to have a health checkup and other facility. All these facts should go to show at least this petitioner is not at all involved in either of the activities. Did find my health, the page 13 is the my service as secretary in the school. Then page 60, is the birth certificate. The original is at page 61. And page 59 is the marriage certificate. Yes. All this considering Lordship will at least consider for grant of bail to this petitioner subject to what the PP says.
Yes, Mr. Sharma.
Possession, these things were not recovered from my possession. First of all, they surprised they already baby, the case of 1981 has been already been referred before your Lordship. And another baby the case, that the betting has to be there, that element is not there, here. Then in another judgment of this court, the goods were recovered, from a place not from the possession of the person concerned. So therefore, it says this act is not applicable so far as the gambling act is concerned. So far as only 143, that of course, how I have been involved in procurement and then the rest part of the exploitation, etc. That of course, the CG will reveal.
Okay. Okay. Yes, Mr. Sharma.
Just to clarify, in the case that there is a list of the rooms, Lordship, who were staying in each room. Here, Lordship will find that in the room number 1, from where recovery was made, Lordship, that room belonged to the petitioner in item number 23. But Lordship, the present petitioner, his room number was 8, which he checked out, and thereafter, Lordship, during the seizure, he was found in the room number 1 along with the petitioner in 23. In room number 1, he was found.
But from his possession, no.
1, 3, and 8. Room number 1, 3, and 8 were articles were found. 8 was registered in his name, but he checked out and he was present in room number 1, which belonged to the petitioner number 22. So that allegation also is there. Next, Lordship, coming to the 143 also, Lordship, the victim girls, as I have already pointed out, they have already implicated this person's, Lordship. And regarding the gambling part, Lordship will find, as I pointed out, Lordship, some names have come up now, Lordship, regarding the gambling racket part. Those numbers are under consideration. The people are sought to be arrested, Lordship, but they are absconding. And that apart, Lordship, one more aspect is there, Lordship, the name of a big company has come up, Lordship. So that is also under investigation. Their accounts have been freezed. So investigation is still going on, Lordship, and Lordship, the IO has also stated, Lordship, that releasing this petitioner at this stage, Lordship, will
be detrimental to the investigation, Lordship.
But
because-
offense under Assam Games and Betting Act is punishable up to 3 years only.
Yes.
So how long can you detain them?
Lordship, the statutory period, Lordship, it is based, Lordship, it is not, it is a based on, Lordship, the investigation. Lordship is seeing the investigation, how it has progressed. Whether, Lordship, their interrogation is necessary or not, that is the consideration, Lordship.
Yes.
The statutory period is 60 days, Lordship. Now today is 19 days, if I'm not wrong. And Lordship, based on the investigation, Lordship will see some names have cropped up. If they are released, Lordship, they are going to be detrimental to the investigation, Lordship, because all these persons, they are already absconding, Lordship. So that is a crucial part of investigation that is going on, Lordship. Now it is only 19 days, Lordship.
Okay.
That is my submission with regard to present petitioner, Lordship. And 143 allegation is also there, Lordship.
Okay.
The victim girls, Lordship, they have all implicated these present petitioners. Lordship, kindly go to the 183 statement.
And he has been falsely implicated in this case. He submits that petitioner is presently working as a secretary of a school at Mizoram, and he had school at Mizoram stop. He further submits that though the petitioner had booked a room in the aforesaid resort, however, before the search operation was carried out, he had already checked out of the said room. Checked out from the said room. Learned counsel for the petitioner, learned senior counsel for the petitioner submits that no seizure of any instrument or article which may be used in games and betting have been seized from his possession, and therefore seizure, even the seizure list does not indicate his name. He also submits that the petitioner is in no way involved in recruitment of any girls for the purpose of exploitation, and therefore there are no ingredients of offense under section 143 of BNS against the present petitioner. He also submits that no one was found found while gambling or betting at the place of recovery stop. He submits that mere recovery of instrument or articles which may be utilized for games and betting does not constitute any offense under Assam Games and Betting Act. In support of his submission, learned senior counsel has cited a ruling of the apex of this ruling of a coordinate bench of this court in the case of Devi Bhattacharjee versus State of Assam, reported in 1982 SCC Online, GAU 50, as well as GAU 50. Learned senior counsel for the petitioner also submits that the Assam Games and Betting Act entails maximum punishment for 3 years only, and considering the fact that there is no material to implicate the petitioner in the offense alleged under section 143 of BNS, he prays that the petitioner may be allowed to go on bail. He also submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor Mr. B. Sharma has vehemently opposed the grant of bail to the present petitioner and has submitted that from the case diary, it appears that though the petitioner, it appears that the petitioner had booked room number 8 of the said resort and he was staying in the said room. However, before the search operation, he had already checked out from the said room. Though before the said operation, he has checked out from the said room, however, he was found in room number 1 at the time of search operation, from where learned additional public prosecutor also submits that from room number 1 also articles/materials which may be utilized for the purpose of gambling and betting have been recovered. Stop. Learned additional public prosecutors also submits that the victim girls whose statement have already been recorded under section 183 of BNSS have implicated the accused persons named in the affair, including the present petitioner. He also submits that there are few more victim girls whose statements are yet to be recorded, and there is indication in the case diary that those victims, some of those victim girls might be minor. Stop. Learned additional public prosecutor submits that the investigation is at a very crucial stage, and therefore, considering the early stage of the investigation, he prays for rejecting the bail application of the petitioner.
Like with submission, my lord, I have only one submission. The mayor presence, my lord, even if it is, my lord, I am denying that I was not present even in the room number 1, but even if it is, my lord, taken on face value, what this Thursday says, that room has to be a betting house. Apart from gambling plate, mayor presence in the betting house then may constitute the, my lord, offense under that section. So that is not a, my lord, betting house. And so far as, my lord, the possession is concerned, my lord, the other judgment which I have referred to, my lord, is paragraph 10, my lord. They also possession from the person concerned, the possession was not there.
Para 10 of which judgment?
Unreported, my lord, criminal revision petition 14 of 2012.
Yes.
The third line. It is seen that essential ingredients of offense under section 13 and 14 of 1970 Act could not be brought from against the petitioner as the prosecution could not establish that any gaming and betting instrument that was seized was from the possession of the petitioner here. Had I been present and it was from my possession, seizure list would have definitely reflected my name. But it is not there.
Okay. Line or red. Oh yes, line or red code. Learned senior counsel for the petitioner, it will go in that paragraph where senior counsels. Learned senior counsel for the petitioner also submits that even if assuming that the petitioner was found in some other room when the search operation was going on, his mere presence may not constitute an offense under Assam Games and Betting Act when nothing was seized from his possession. He submits that in the instant case, no offense under section 13, 14, no offense under section 14, 15, 16, and 17 of the Assam Games and Betting Act has been made out against the present petitioner. In support of his submission, he has cited a judgment of a coordinate bench of this court in the case of Motiur Rahman and another versus State of Assam within bracket judgment dated 26/6/2020 in criminal division petition number 14/2020. Stop. He also submits that the petitioner is suffering from heart ailment and is under constant medical treatment. And considering his ailment, constant medical treatment, stop. He also submits that petitioner got married in the year 2023 and has a
child of about 1 year.
As a child of about 1 year to look after. And as the petitioner is in custody, they are in great difficulty. Tarpisot, they continue submission. I'll deliver order day after tomorrow. Heard Mr. P.J. Soikyalanen, Senior Counsel, assisted by Miss. Which item number?
20.
M. Kichi, Learned Counsel for the petitioner. Also heard Mr. B. Sharma, Learned Additional Public Prosecutor. Release this matter for delivery of orders on 6th of August 2020. Itu record.
My lord, with all respect, my lord, Lordship has gone through the case diary past orders, my lord. My lord, there are two parts of it, my lord, the factual metrics and the legal metrics, my lord. With all respect, my lord. Primarily, Lordship's rejections orders are, my lord. With all respect and folded hand, my lord. So far as I may be misquoting sections, my lord, section 143 of the BNS, my lord.
Yes.
The other sections are, my lord, with all respect, my lord. That entails the punishment at the end of trial if convicted, my lord. AGPP Act, my lord. Assam Game and Betting Prohibition Act, my lord. 3 years, my lord. Those are also non-bailable, my lord. And the other legal metrics is, my lord, the section of law attributed. First, as I said, my lord, 143. There are human trafficking, my lord. Thereafter, AG, my lord, Assam Game and Betting Prohibition Act. And on the top of it, my lord, with all respect, I would submit, my lord, 3174, my lord. That entails a punishment, possibly of life imprisonment. But that too, my lord, what the definition of that section says, my lord, receiving stolen property. When I read that, my lord, kindly peruse it. Let me go section wise, my lord, from 143, with all respect, my lord. In my understanding as a student of law, my lord, with all respect and folded hands, my lord, instead of 143, my lord, it has to be a particular section of the Immoral Traffic Act. And that is reflected, the factual metrics, lordship rejections order, my lord. That I'll place, my lord. Can I first, my lord, in my understanding as a student of law, my lord, I'll read 143, my lord, with all respect, my lord. And what the
My lord, Indian criminal justice delivery system, my lord, despite my lord statutory provisions, constitution is at the top, my lord, certain things are by way of Article 141, what the apex court has said. If that I'll also place at a later stage, my lord. I'll be very cryptic, my lord. With all respect, my lord, regarding the legal metrics, 3 sections of law primarily, my lord. 143, my lord, human trafficking. First, my lord, let me begin from 143, my lord, with all respect and full reverence, my lord. What 143 says, my lord? With all respect, can I just?
Yes. Yes.
May 143, trafficking of person, whoever for the purpose of exploitation, meaning thereby is like a promise which has to be since there in inception, earlier Indian my lord, IPC 420. Whoever for the purpose of exploitation recruits, my lord, I am not a recruiter, I am a guest, transports, no connection, my lord. But first of all, the section has to be applicable to attribute a section of law, my lord. Harbors, I have never harbored, my lord. Transfers or receives a person or persons by using threats, meaning thereby the residence, place of origin.
What is the purport of the word receives?
Yes, my lord. I'll come to that, my lord. Receive means
Through threat.
through threat.
Not by way of.
A lady who is, my lord, major lady, human trafficking from one place to another, thereafter she doesn't complain. With all respect, my lord, kindly see, visualize what the law entails, my lord. Yes, my lord, assuming receiving, who received? I cannot name the resort owner, that be bad, my lord. If my lord, some other co-accused, I'll be hurting them, my lord. I'm not saying that. Did I receive? Your lordship's order, may I just read it at this moment, my lord. For a price, if I use a girl, major girl, even a minor girl, my lord, I do not ask a girl, if I go for fun and frolic, my lord, what is your age? It is the provider who is to look into it, my lord. I do not have access to the case diary, my lord. But this line reflects, my lord, para 21, my lord, on perusal of the case diary.
Yes.
May I, my lord?
Yes.
It appears that in the case diary, which indicates the complicity of the owner of the club so and so, namely so and so, in an alleged offense under section 143 of the so and so, and the various provisions of the Assam Game and Betting Act 1970, one of the victim girls whose statements has been recorded under section so and so has categorically implicated the owner of sexually exploiting her. Brought from where, trafficked from where, then this word, my lord, received by whom? I did not receive. It cannot be. Under no, is there any evidence to that effect? If I fall in the, I do not fall in the category of receiving. It is the person named, he may have received or not, I do not know. She was also sexually exploited by the guest of the said resort in lieu of money. What does it mean? There's a prostitution racket going on, assuming the allegations are true.
What is this meaning? What is the meaning of receives in this case?
First of all, procurement has to be there. My lord, human trafficking, the girl has to be trafficked from one place to another.
Suppose some other accused.
Heads, my lord. All brothels, my lord, kindly see. Licensed brothels are there in metropolis, my lord. There what happens? The girls may have been, this human trafficking may have taken place. That is between the brothel owner and the, my lord, not the customers, my lord. How can they?
Licensed brothels are there?
Yes.
Under what law? You are making wrong submissions.
My lord. Metropolitan cities, my lord.
Under what law?
Look at the state laws, my lord, in my understanding. Because Sunagasi and everything in West Bengal, my lord, that's no police section, nothing. There has to be a local law somewhere. That I'll find out.
You are
my lord.
assuming,
My lord.
you are assuming.
No, otherwise, how can it operate, my lord, upon?
No, that we don't know, but
Anyway, then I will omit my submission, my lord.
because I will rely your submission. You have
Rely
to
on
be
that.
very careful when
No,
you
no,
make submission.
I said it is operating apparently, my lord.
No, you said that licensed brothels are there.
That otherwise, how can they operate openly, my lord?
No, don't did
Carried away, my lord.
no, not carried away. Without
Then
facts,
it, my lord. I omit it.
yes.
Say that. But anyway, my lord, kindly visualize a situation, my lord. The section entails human trafficking. What is trafficking, my lord? A major girl traffic. First of all, she has to complain somewhere. Is there any date in the case diary on which day she was trafficked from which place?
No, suppose she does not complain and the FIR
Then-
has been lost by somebody else who came to know about the incident.
Here, my lord, kindly see. The girl who has given the statement, with all respect, my lord, what it is there in the statement, I do not know. The girl receiving is what, my lord? I received it subsequent to the first traffic girl being received by somebody. That
No,
can be.
I don't know the meaning, therefore I am asking you.
I'm sorry.
I am not saying that you fall within that category or not.
No.
I am only asking the
In my
meaning.
understanding as a student of law, my lord, receiving would be the girl is trafficked from say point A. It is received by another trafficker, my lord. The girl is subsequently used in prostitution by customers, my lord. Would they fall within the, my lord, that is the head note. Thereafter, let me continue down below, my lord. A, B, C, D, E, F, T left. Do I fall, my lord? Can I, my lord? Regarding receiving, my lord, that would be, my lord, many receipts then, my lord. If girl is trafficked, engaged in prosecution, with all respect, my lord, not prosecution, prostitution, my lord. In that event, my lord, there'll be many receivers, my lord. That cannot have, it would have been in plural, my lord.
Okay.
In my understanding as a student of law, my lord. Don't break my understanding. My lord, first A, using fates. Did I traffic the girl? Is it there in the case that I trafficked her from her place of residence by using force? No. Using force or any other form of coercion? No. By abduction? No. By practicing fraud or deception? No. By abuse of power? No. By inducement, including the giving of, receiving of payments or benefits in order to achieve the consent of any person having control over the person recruited, meaning thereby girl's parents or guardians, my lord. This F, my lord. Transported, harbored, transferred, received. This receiving is, my lord, a girl is used, brought to a brothel, trafficked from Assam, taken to Calcutta, my lord, sheltered in a brothel. That first sheltering, my lord, that would be receiving, my lord.
Okay.
Thereafter, the customers, unfortunately, my lord, this is very sad. The customers, with all respect, my lord, who utilize their, my lord, promiscuous services, my lord, cannot be a receiver, my lord. So I do not, with all respect and folded hands, my lord, in my understanding as a student of law, cannot fall within the ambit of 143. In my understanding, my lord. If Lordship may have any queries, Lordship may. I am at your Lordship's disposal, my lord.
Okay. Now continue your submission.
My lord, can I, my lord? Now I at least see, my lord. The legislature passes laws in their wisdom, my lord. So legislature in this BNS, my lord, earlier it was 370 IPC, my lord. Replica no hoy replicated here, my lord. Have I made my position clear, my lord? Despite the IPC is, my lord, generations.
How section 3 within bracket 5 comes into picture in this case?
Common intention, my lord. Common
When-
intention, my lord,
When read with 143,
no.
still
This
it does not come against you.
Can I come to my answer, my lord? I may be wrong, my lord. Also could clarify me, correct me, my lord. And if wrong submissions are made, my lord, also could kindly stop me, my lord. But here, whatever I have understood, my lord, that common intention part is regarding this 29 room guests, my lord, who enjoyed the girls. They brought it at a subsequent stage, my lord. Is there any evidence in the case that Lordship has perused that there was common intention while procuring the girl, trafficking the girl from the outset, my lord, where she resided, thereafter the girl was brought to Guwahati? Is there any evidence in the case diary, my lord? 161 statements, not to talk about 164. Have I made my question clear, my lord?
Yes.
And inserting a section, my lord, the Alsatian authority wherein it says, my lord, despite, my lord, these dictates of the Supreme Court, my lord, this Ernest Kumar and all those prior, my lord, these authorities are authorities, my lord, to be respected. There is a full man's authority, my lord. Police cannot, with all respect, my lord, in their wisdom, register a case, arrest people, and start investigation thereafter, my lord. It is a classic case. Here, my lord, can I say one thing, my lord, not related to the case, my lord? What has happened is that, kindly see, my lord, that 2G scam. Plain reading, my lord. Initially, it was made out to be a scam of 1,74,000 crores. 1,74,000 crores. 2G, my lord, spectrum. Then ultimately, what happened, my lord? Many senior people, my lord, political, my lord, at the behest of political leader, they were arrested and subsequently acquitted by the trial court itself. Anyway, this is just by way of reference, my lord. Here, my lord, what has happened? In my understanding,
No, in 143, the main offense is of exploitation.
no. Main offense has to be, my lord. First of all, the girl has to be trafficked.
No, you read again.
Yes, my lord.
The offense is of exploitation
Well,
for
can-
the purpose of exploitation.
Whoever
If you
for the
do
purpose of
certain thing.
exploitation,
So,
recruit.
so purpose is, the purpose is of.
I am talking about the head note, my lord. Traffic. Then we'll have to go to the
For-
legal lexicon, my lord.
No, for the purpose of exploitation of a girl.
Yes, my lord.
If you do 1, 2, 3, 4, 5,
Yes.
then you are liable under 143.
These are giving.
Yes.
These are giving.
So the girl is exploited not only by the person who recruits, but who is the ultimate.
Can I answer if we have
Yes,
with my
this
limited
you
knowledge, my
clarify,
lord.
clarify.
With my limited knowledge, my lord. Then why this act is in existence? IPC came into being section 370. That is when ICP, my lord, IPC came into being, my lord. 180 years back, my lord. Thereafter, it is replicated in BNS. Have I made my position clear, my lord?
Yes.
Thereafter, this act was passed.
Which act?
My lord, with all respect, my lord, the Immoral Traffic Prevention Act, that too in 1956 only.
No,
And
but
specific
there are many offenses which exist in IPC, but for which offenses special law also exists.
My lord, in that case, the special law will prevail. Digmuti, my lord.
No, but the case is at the stage of investigation.
My lord, I have understood. Then say they should not have arrested me. After I'm not meaning completing investigation. After finding out materials that whether it is a case as regards the case, whether it is a case under the Immoral Traffic Act or the, my lord, section 370. Plain reading of the section, my lord, I cannot fall within it.
Okay, your submission is that ingredients of 143 are absent as against you are concerned.
I do not attribute names, my lord, because that will be disastrous.
But as
My friends
against
are
you,
fighting for them. So far as the guests are concerned, my lord. Have I made my position clear, my lord?
yes.
Regarding them,
Your submission is that guests cannot even be implicated under section 3 within bracket 5.
absolutely, my lord. And with my lord, with my understanding as a student of law, Lordship may correct me. If I read it many number of times, let us not to go to authorities, my lord. What 143 says. And despite it being there in the, my lord, IPC, since its inception, This is a replication only, my lord. Thereafter, in 1956, Immoral Traffic Act come. And if there are two laws are loggerheads, the special law will prevail. That is Digmurti, my lord. IT Act and, my lord, we have sections of the IPC, my lord. If necessary, Baba, I can place it any day, my lord. With all respect, my lord. Digmurti is asset. And now, my lord, in a situation like this, let me come to the section of law so far as immoral trafficking is concerned, my lord. Lordship order reflects the materials in the case diary. That line again I am reading out, my lord. Mike, how can I procure the girl from her residence, my lord, traffic her, thereafter exploit her? That is the head note. Because thereafter A to F, do I fall? It has to be read in totality, my lord. Not partially, with all respect and folded hands, my lord. This last line, my lord. She was also sexually exploited by the guest of the resort in lieu of money. Girl never protested if we enjoyed them. In lieu of money. We paid money. Is it not prostitution? When it is a specific case of prostitution, would it fall within human trafficking? I do not belong to the management, or would it fall under this act, my lord? May I just come to this act, my lord, with all respect, my lord. This otherwise the law would have been struck down, my lord. The 1956 law, my lord. And there are several authorities of our High Court that also I'll be placing, my lord, at the same time, if your lordship permits me. My lord, section 7. My lord, bracket of prostitution. May I just read it and hand it over to your lordships, my lord?
Yes, no, what do you want to submit?
That this law would be
that even if assuming that some complicity is there, it would
if complicity is there in human trafficking.
no, let me ask the question.
Sorry.
Complicity is there, it would be under Immoral Traffic Prevention Act
We entered the hotel.
where the offenses are bailable.
No, we entered the hotel for gambling, criminals were. Thereafter, my lord, in their eyes, thereafter, my lord, girls were provided to us. We enjoyed their services or tried to enjoy their services. With all respect, my lord. Have I made my position clear, my lord? My lord, mere visualization, my lord. Can it be human trafficking? Or it would be this section of law I'm reading out, my lord. With all respect and full in the care. Can I, my lord?
Yes.
Section 7, my lord. Prostitution in or in the vicinity of public places. Because the girls did it without complaint after being trafficked. True, untrue, lordship would decide. No complaint. Thereafter, with all respect, my lord, they for money sell their bodies. As per the materials in the case diary. Whom such, my lord, kindly may I read out, my lord. Thereafter it begins, my lord, prostitution in or in the vicinity of public places. Any person, with all respect, my lord, who carries out on prostitution and the person with whom such prostitution is carried on in any premises, which are within the area notified under 3. The public prosecutor may go through it, my lord. We are within a distance of 200 meters of place of religious worship, educational, so and so, so and so, so and so, so and so, in the manner prescribed, shall be punished with an imprisonment for a term which may extend to 3 years. As per the second schedule, 3 months, my lord. This is bailable. Regarding the, my lord, not only customers, the trafficked women who sell their bodies as per this act, my lord. It is a specific case for pleasure they were used. Do I know the girl from before entering the hotel? Is there any evidence in the case diary?
Okay.
This is my case, my lord. And my lord, can I, my lord? Of course, my lord, I will not read it out, my lord. These are all authorities saying that when a prostitute, I should not say, my lord, lady who sell their bodies, my lord, or customers are arrested, my lord. Many number of orders, my lord, because it being bailable, immediately granted the privilege of bail. I'm just reading out the line. 6 days, 4 days, my lord. Kindly see. This is bail application number 590/2016.
No, these
Immoral traffic.
under, yes, immoral
kindly let us visualize a situation, my lord. That lady may also have been trafficked by someone. Here also may have been trafficked, may not have been trafficked. The statements are being collected now after 20 days. Kindly see. While reading, I'll place the factual metrics before your lordships. I'll go into that, my lord. Otherwise, I'll digress myself, my lord. Vijit Jain, my lord. Section 7, bailable. Vinit Jain, that is.
Okay. Okay, what else is your submission?
Regarding non-applicability of section 370, my lord.
Okay, that agreed.
My lord, the rest, my lord, these orders are there, my lord. Anyway, lordship may peruse it with all respect, my lord. These are orders, my lord. Secondly, my lord, the other non-bailable of section of law, my lord, receiving stolen property habitually. This is the most heinous in my understanding, because the quantum of punishment is life, my lord. Section 3174, my lord.
Okay.
3174, my lord. Most heinous, my lord. Here, my lord, it would not be only receiving stolen property. The stolen property, the arrested person must be receiving stolen property habitually. Have I made my question clear, my lord?
Yes.
So attribute a section of law, investigate thereafter, so that I can be collect material, so I can be booked under that section of law. Can it happen, my lord? May I read now, at the same time I read, my lord, what they say regarding attribution of 317(4), my lord. Page 40 of my application, my lord. Second forwarding report. You cannot make a mountain out of a molehill, my lord.
Yes.
40. May I, my lord?
Yes, please.
Paragraph 9, my lord, with all respect and folded hands, my lord. During the course of investigation, it has been clearly established that the arrested accused person failed to produce any document such as UA bills, meaning thereby receipts, my lord, purchased by online or whatever, purchase receipts, or any proof of lawful acquisition of the article seized on 15/7/25 from Club Nirvana, Medikusi. Have I made my question clear, my lord?
Yes, yes.
If it is Club Nirvana, is there any material in the case that is the guests who were occupying the rooms or who fled away, or these 3% in whose room poker was being carried out? And by the way, my lord, poker can be played without money also. It is not that only money has, because there is no recovery of money. I'll come to that, my lord, with all respect, my lord. My lord, with all respect, kindly see. Oh, this is fun, my lord, English literature and no law. Can it happen, my lord? To produce any document such as UA bills, purchase receipts, or any proof of lawful acquisition of the articles.
Okay, 317 is not there.
My lord?
317.
Can I just go 2 more lines, my lord? Then
Yes.
it will be a case under custom sake. I'll come to that, my lord.
Yes.
Apparent. Kindly see, my lord. Lordship has with a vast explanation on this thing, my lord. If some stolen property is found, there has to be, my lord, with all respect, 303 BNS first, my lord. First is there is to be a complaint that it is stolen away. Am I correct or not, my lord?
Yes.
Thereafter, the subsequent 317 would come, my lord. If he has been receiving stolen property from the same sources many number of times. Here is no complaint, my lord. And what they say, that these are brought from foreign countries. Hurry, foreigner would come and complain, then my property has been stolen, or it would fall in the ambit of the, my lord, with all lesser customs act, my lord. And below, these materials should be valued how much? To the bailable offenses, my lord. Kindly see, you cannot create, by literature, create insert sections of law and justify it subsequently. May I just read 2 more lines, my lord? From Club Nirvana Medikusi. And if it is from Club Nirvana, this line, my lord, kindly see. Now it is being attributed to rooms. The 3 gentlemen who occupied it, or 3 criminals who occupied it, they procured by way of receiving stolen property habitually. If it is from Club Nirvana, have they verified whether it is Club Nirvana property or, my lord, guest property? Have I made my position clear, my lord?
Yes.
There has to be evidence, my lord. Good legislation is no law, my lord. The seized items 220 Casio poker chip. I'm taking your time, my lord. Beverages have been leaving aside some lines. Etu kora se foreign opera anise. My lord, this is this, my lord. Investigation has revealed, they have investigated and it has revealed that these articles were illegally sourced from other states of India as well as foreign countries. Have I made my position clear? One time you say stolen property, habitually receiving. Now you say, kindly find out in the case diary how they have found out this line, why it is inserted. Good literature does not tantamount to bringing a case within the purview of a particular section of law or its ambit, my lord. Investigation has revealed that these articles were illegally sourced. Am I correct, my lord? This is their language, not my language. I'm reading it out. Unfortunately, there is a criminal justice delivery system, not banana republic, my lord. Illegally sourced from other states of India as well as foreign countries and were received and possessed by the arrested accused persons and their associates. First line say from Club Nirvana premises. Now, you implicate the case. Have I made my position clear? They are in 2 months, they do not know. And if I bring it from foreign countries without paying duty, custom duty, would it be receiving stolen property? And my lord, kindly see, if somebody, my lord, a stolen property is found out, suspected to be stolen property, then under what section of the police is to register a case? Earlier times, my lord, IPC times, it was, my lord, with all respect, my lord, 41 CRPC with a view to prosecute under section 411, my lord. Have I made my position clear, my lord? That is the practice, that is the law. First of all, you have to find out whether it is stolen property or not. And now they habitually receiving stolen property. This time also you have not established that it is stolen property. Am I correct? Under this, had the case been registered only under this section of law? Would you have arrested me? You procure the girls and thereafter give their statement subsequently. Girls also fade away, my lord. That actual metrics part I'll come, my lord. I'm taking 2 minutes, lordship would not otherwise. So, my lord, 317(4). My lord, kindly, my lord, with all respect, visualize a situation, my lord. Can it happen? This is their writing. Have they investigated to the extent that those articles were stolen away from which country, from which place, my lord? No. This is the case of arrest first and investigate thereafter, my lord. At this time itself, my lord, I read the Supreme Court authority, my lord. Otherwise, I'll forget, my lord. I'll be very cryptic, my lord. With all respect, my lord. What the apex court has said. When there is no statutory provision, say Article 2, my lord, this thing, 22(1), that, my lord, forthwith the grounds of arrest are to be provided. That is in Article 22(1), my lord, constitutional mandate. Thereafter, the statutory mandate. 47, 48 now, my lord. Have I made my position clear, my lord?
Yes.
When it is not there in law, neither in the statute, I'm not talking about the constitution because it is covered by Article 21. No person shall be deprived of his life and liberty except according to procedure established by law. Is it the procedure established by law? You arrest first and thereafter investigate. What apex court has said, my lord, I just read it, my lord, and place it before your lordship with full hands. Joginder Kumar, my lord. My lord, benchmark case, my lord.
Which para?
1994, my lord. Para, my lord. I'll be very clear. Too many paras, I'll read only one. Para 20, next page, my lord.
Yes. Now, what you want to emphasize?
Kindly let me read it, my lord. Thereafter, it will come out, my lord. That this is not done. Arresting first and investigating thereafter, my lord. It may not be there in the statute, but it is barred to the detriment of the policeman also. It is written there here, my lord.
Yes, please read.
The above guidelines are merely, lordship has found, my lord.
Yes.
After that, Roman.
Yes, please read.
I'm sorry, my lord. The above guidelines are merely the incidents of personal liberty guaranteed under the Constitution of India. No arrest can be made because it is lawful for the police officer to do so. Here it is lawful, my lord. Have I made my position clear? Cognizable offense, non-bailable, my lord. They have attributed their case. Anyway, my lord, he has a power to arrest. This line is important, my lord. No arrest can be made because it is lawful for the police officer to do so. There has to be some investigation first. The existence of the power to arrest is one thing. The justification for the exercise of it is quite another. Arresting, that there has to be justification, my lord. The police officer must be able to justify the arrest apart from his power to do so. I have read out section, my lord, with all respect, my lord, 143, and then 3174, no material. Arrest and detention in police lockup of a person can cause incalculable harm to the reputation and self-esteem of a person. I'm a practicing lawyer of the High Court. I may have played poker, my lord, and thereafter, for a bailable offense, I may have enjoyed gulf as per police, my lord. As per me, I was not doing that. No arrest can be made in a routine manner on a mere allegation of commission of an offense made against a person. Here, my lord, FIR has been lodged by whom? Policeman, no? FIR has been lodged by policemen. Same police station is investigating. There are hundreds of authorities, my lord. Illegality, because to prove their case, they will go to any extent, and this has happened here, my lord. It would be prudent for a police officer. This line is very important, my lord. It would be prudent for a police officer, in the interest of protection of the constitutional right, meaning thereby Article 21 of a citizen, and perhaps in his own interest, so that there be no litigation against the policeman. If this case goes to CBI, because now nobody will file, fearing they will not get paid. Kindly see, my lord, that no arrest should be made without a reasonable satisfaction risk after some investigation. This line again, I missed out something, my lord. I'm reading the line again, my lord. It would be prudent for a police officer in the interest of protection of the constitutional rights of a citizen, and perhaps in his own interest, that no arrest should be made without a reasonable satisfaction risk after some investigation. Here, my lord, arrest has been done. Investigation is being carried out now. For 143, they are collecting materials now. Some more girls are to be examined, my lord. Can that ground lead to the possibility of denying my right of getting bail? No. Made with a reasonable satisfaction this after some investigation as to the genuineness and bona fide. What investigation, my lord? It is not there in the statute. Without a reasonable satisfaction risk after some investigation as to the genuineness and bona fide of a complaint. Here the complaint itself is a policeman. And if necessary, I'll place authorities that when police, my lord, lodges the FIR and investigates the same case by the same police station, it is, my lord, against the concept of law, my lord. And a reasonable...
Not by the same police station, by
by
the same officer.
Huh?
Investigation cannot be done by the same complainant.
Exactly, my lord.
But in the
Let us go, after all, to Article 20, let us go to a higher height, my lord.
that is your submission only.
Yes, I'm submitting only, my lord.
But you are saying
Sorry, my lord, in 2 days' time, I'll find out authorities on that. Yes, these are Naxalite killing cases. I read, but I cannot quote now. I'll find out, my lord.
Okay.
If necessary, I'll find out. Only one wrong submission I made, my lord, that I'll find out also that, my lord, that whether in this metropolis, my lord, police never raid. That cannot happen, my lord. I'll find out. By municipal law or something, possibly, my lord. Of course, that I omit, my lord, as your lordship has rightly pointed out. Because of over-jealousy, I may have said that. But I'm sorry, my lord. And hereafter, my lord, can you read one more line, my lord? Can I, my lord?
yes.
Made without a reasonable satisfaction risk after some investigation. Here there is no investigation, now they are investigating. As to the genuineness and bona fide of a complaint, here the complaint is lodged by a policeman, and a reasonable belief, both as to the person's complicity and even so, exactly, my lord, this is the, my lord, I'm putting emphasis. As to the person's complicity, yes, there is complicity. Without inserting this human trafficking and receiving stolen property. Is those sections move out?
Okay.
Then, my lord, only extend to 3-year remains.
Okay, your submission.
Any event so as to need to effect arrest. Have I made my position clear, my lord?
Yes.
This much, my lord. And thereafter, are you going to develop it? 14 game and getting. No, sir, Malkin, My lord, regarding game, I'm taking 2 minutes. Can I, my lord?
Game and betting bailable offense.
No, no, factual matter, just 2 lines, my lord, if possible, if the
Yes.
lordship allows me.
Yes.
But I'll not go into it, my lord, there are 3 years.
No, no, what you want to submit?
I wrote something homework, my lord, I read it and face it before your lordship.
Yes.
From my conscious position, my lord, kindly. see-
Nothing was seized.
No, no, please, my
Yes.
lord. Page 52. Roman XX, 22, my lord. One iPhone 60 Pro Max along with one wallet having cash amount rupees 680. Have I made my position clear, my lord? There are two aspects to it, my lord. Either after completing the game, the gamblers who fled, they may have carried away the money. Against me, I'm implicating myself, my lord. Have I made my position clear? But at the end of trial, what will happen? And if now after 20 days they say, after arresting me without investigating, that regarding on the game was never online, my lord. It was fun and frolic, my lord, as I have been told. Online, let them give. I do not seek bail today. Call for a report as to how much on the 20th day, how much money was transacted online. You have huge authority, my lord. Now even this, my lord, what you call that? WhatsApp messages. One day they can break it. This Assam Police, the headquarter, this thing, laboratory, and the Aizawl laboratory, my lord. So, my lord, getting this information, they do not need time.
Okay.
And my lord, kindly see, to pay online, TV sets are to be, because looking at faces, gamblers gamble. Look at this, my lord, this Singapore and everything. It is on the screen. Otherwise, you cannot play online gambling. You never know the mode in poker. It's a game. And Supreme Court has said it's a skill game. I'll not go into that, my lord. Wastage of time, because they've already arrested. So what is the seizure, my lord? Now the factual matrix, 2 lines I'll take, my lord. I have taken much of your lordship's time. Lordship will forgive me for that, my lord. Factual matrix to show. Why my bail application was why my bail application was objected? I'm just reading it, my lord. They must have inserted the sections subsequently and wrote this forwarding report first. They talk about not issuing 35-3 notice, my lord. By that time, possibly, when it was drafted, copy paste, my lord, they failed to do one thing, my lord. It could have been an offense, only the gambling offenses. That is to a possible presumption, my lord. Kindly see. Page 25, first forwarding report. First forwarding report, my lord. Page 25. Can I read it out, my lord?
Yes.
With all respect and folded hands, my lord. The below-noted accused persons are arrested in connection with the instant case for the following reasons. If the accused persons are not arrested, then they might have fled away and their presence before the Honorable Court could not be ascertained wherever necessary. I am a practicing lawyer, my lord. I may be a gambler. I may have enjoyed the company of girls. These are allegations, my lord. I am a practicing lawyer. I'll never run away, my lord, in my lifetime. That too of the High Court Aizawl bench. The custodial interrogation of the accused person is very much essential to identify and arrest their associates. I was taken into police custody for 9 days, my lord. Oh, sorry. I'm sorry, my lord. 7 days. 7 days, my lord. The arrest of the accused persons are strongly required for proper investigation of the case. This line shows that Joginder Singh authority was violated in totality, and that is an Article 141 authority, my lord. The law laid down by the Supreme Court shall be applicable to all courts throughout the territory of India, my lord. With all respect, my lord. This paragraph,
What it says?
My lord.
What Joginder Singh says?
Yes, I read out, my lord. Yes. Arrest after investigation.
Okay.
Here they have categorically stated. Kindly see. How can there it is in black and white. This should be holder. The arrest of accused persons are strongly required for proper investigation of the case. My goodness.
Okay.
The legal advisors should put some more legal acumen thereafter. The arrested accused persons are financially sound and influential persons, and if they are not arrested, they may commit similar offences in and around Guwahati city. And seize, my lord, 5,000 rupees or my lord, that I read out. Oh, sorry, 680 rupees, my lord. Reasons for applying, no, not applying 35 fee. Kindly see. Meaning thereby, you don't issue a notice when it is.
Okay, your submission is that 143 was initially not there. Later on, it was inserted.
In my understanding as a student of law, lordship would be.
We'll verify from the case.
It is a, my lord, here it is like this. So the two sections are impossible if under no circumstances, as a student of law, as I do understand, comprehend, feel, palpably, my lord, cannot be applicable. Receiving stolen property habitually, they gone on day one, my lord, from foreign countries. They do not know as to whether it is stolen property or not.
Okay, you have to at one point of time conclude.
Yes.
Otherwise, I will forget what you have.
I'm
What?
sorry. My lord, my prayer is, my lord, my prayer is only one part, my lord. Gambling may be a small offense, 3 years, my lord. Have I made my position clear? Seizures were made from rooms, whether from the, it belongs to the management or to us, my lord. That doesn't make any difference. My query is, my lord, regarding, my lord, if it is online gambling, on the 20th day, please call for a report regarding me, my lord. Others, my lord, I don't know. Lordship will pass order accordingly, my lord. If I remain for some days, doesn't make any difference. Truth has to come out because two offenses does not attract me, my lord.
Okay.
And the rest as well. But if there is online gambling, have I made my question clear? If it is online gambling, what quantum was transacted? Specific report from the police. Now, if they say we are investigating very hard case, technical devices, kindly allow me to go. At that point of time, any convenient date.
Okay, yes.
And there
Mr.
are another thing, my lord, kindly see. There were 29 rooms. Oh, sorry, 32 rooms, my lord. 30 rooms, rest stayed away. Or if those were unoccupied, the resort register will speak. Lordship has perused the case diary. So Lordship knows what attempts have been made to arrest them, my lord. It has to be there in today's case diary. Have I made my position clear, my lord? So my prayer is, my lord, final order may not be passed without SR because two sections are not applicable. In
Okay.
only that part, my lord, that how much has been transacted. Online, nothing, no recovery. Or some have carried away the money, then he has to be caught. Or otherwise, what is the online, my lord, amount? On the 20th day, Assam police so competent with the assistance of so many agencies, in one day it can be found out, my lord. Let them place, if it was online, let them first give them whether it is online or offline. Because the seizures show online cannot take place.
Okay.
Because TV screens were never seized. This is my understanding, my lord. I do not, I seek bail, but I say for clarity, for proper adjudication of the matter, these two reports may be sought for, my lord. As regards me only, my lord. Others will get hurt otherwise, my lord.
Okay.
With all respect, my lord. This is my understanding of the matter, my lord. With all respect and full respect, I have taken time. Lordship has given me time. I'm thankful to you.
Yes, Mr. Sharma.
Lordship, first of all, I have to be clarified, Lordship, whether they are seeking disposal or they are seeking report, Lordship.
No, I'm seeking report.
Their submission is report, but I will try to dispose of this matter.
For report, then Lordship, I have to make some submission. If they are seeking report.
Yes, make your submission.
Regarding report, already Lordship, whether it is bank transaction or what transaction, Lordship, that is in the case that already the accounts have been frozen, bank details are being sought for. It will be investigated, Lordship. They cannot dictate to us, Lordship, whether the report has to be there in 1 day, 2 day, 24 hours. That is not their discretion, Lordship. Yet they are well within their rights to seek the appropriate remedy before appropriate court. This is a bail application, Lordship. We'll confine ourselves to the facts.
Yes.
Merely making allegation here and there, Lordship, it does not suffice. If you want to say something, Lordship, I can.
No.
I must learn to deal with.
Lordship, it is not a question of me liking somebody or not liking somebody. That is not the issue here, Lordship.
I have never said that. I
No.
said I will be listening to your valid
Lordship,
submission.
I have patiently heard him.
Hardly
Lordship,
I
I may be allowed
my lord, I have said I
Lordship, I may be
I am
allowed to
hearing
speak,
your
Lordship.
valid
It is my
submission,
turn,
my
Lordship. I may be allowed to speak. He cannot interrupt me, Lordship.
Am I
If-
interrupting?
Yes, you are interrupting me. If he wants to say
Who's
something,
saying-
Lordship,
who's
he can
saying?
go.
I-
He
If,
cannot interrupt me, Lordship.
if you get provoked,
No, I'm provoked, Lordship.
You
This
may.
is the ethics, Lordship, that has been
Fine,
followed here,
because I
Lordship.
don't
I
know it.
have
No,
never
he has-
interrupted anybody, Lordship.
Mr. Mahajan,
I have
he
never
has,
interrupted.
he has not uttered a single word which can be,
Can I just say one thing?
no,
my-
no, no. Let him submit. Yes,
Yes.
yes, Mr. Sharma.
Now, coming to the facts, Lordship, this is a bail application. We are not looking into the sections that are attributed, Lordship. This is not a criminal petition, nor it is a quasi petition. Lordship.
His crux his main submission is that ingredient of 143
Yes. there-
is not attracted
there-
against.
Lordship is spot on to that, Lordship, regarding that received line, Lordship, or receives a person or persons by, all those factors are there. The statement of the witnesses, Lordship has already seen. There, Lordship will kindly see, they have taken the name of the specific persons, that they are influential person, that before also they were used, Lordship, they were being exploited. And the meaning of exploitation has also been given here, Lordship. The expression exploitation shall include any act of physical exploitation or any form of sexual exploitation. And Lordship, second point, the consent of the victim is immaterial in determination of the offense of trafficking. So, Lordship, whether they have lodged one complaint or not, Lordship, the police will have to investigate, Lordship, if it is found, such an offense is found there, Lordship. So they are investigating, Lordship. So regarding, Lordship, the witnesses concerned, Lordship, 2 new witnesses have come up, Lordship has seen. They have taken the specific name of the present petitioner. And he is the petitioner, Lordship, who has booked all the 32 rooms. And he is the person who has organized the gambling event, Lordship. Regarding from his position, Lordship, all those materials have been seized. Lordship has already perused all those things, Lordship. The bank details have been gone into, Lordship. And regarding, Lordship, gambling also, Lordship, no money was used. It was all done through online means. That is the submission here. If Lordship needs any clarification, I'm here, Lordship. Otherwise, I'm presenting the case then, Lordship.
Okay.
And I will be paying for a final disposal, Lordship.
Can I just one more line? My understanding law, I have placed before your lordships. My lord, it is in English language, interpreting by me or by somebody
No,
else.
what do you want to submit?
Section, lordship would decide
No,
whether that section.
you
of law-
have already made your
Then
submission.
I stop here.
Mr. B.K. Mahajan, learned counsel for the Mr. B.K. Mahajan, উপরত তুমি episode dictate করিম. It is the submission of the counsel. Mr. B.K. Mahajan, learned counsel for the petitioner, submits that the petitioner has not committed any offense as alleged in the FIR against him. He submits that no ingredients of offense under section 143 has been made out in this case against the present petitioner, as the petitioner did not took part in, no, as there is no accusation against him regarding the recruitment, transportation, harboring, transferring, receiving of the victim girls by using the modes mentioned in clause within brackets small a to small f of section 143 of BNS. He submits that even if it is assumed that the accusation made by the victim girl that she was accusation made by the victim girls that they were asked to cater to the sexual favor of the customers are believed to be true. Learned counsel for the petitioner submits that only offense under section 7 of the under section 7 of the Immoral Trafficking within bracket Prevention Act 1956 may be made out against the petitioner, in which case he submits the offense would be bailable. He also submits that the offense under section 317 within bracket 4 of the BNS is also not made out against the petitioner, as there is no accusation made under section 303 of BNS that the property seized in this case is a stolen property. No, in this case are stolen properties. He also, learned counsel for the petitioner also submits that the mere seizure of dice board where is the seizure list?
Page 50.
Page
Page 51, sorry.
Mere seizure of casino poker chips and cards Tambola housing board and lottery bingo machine would not attract an offense under Assam Games and Betting Act unless the accused persons were found indulging in gambling and betting. At the time when they were arrested. He also submits that in this case, the arrest of the petitioner was made even before the arresting authority could gather any material which would have material against him, which would have justified his arrest in this case. Learned counsel for the petitioner has submitted that the manner in which the arresting authority has justified not invoking the provisions of section 35(3) in this case would reveal that initially section 143 of BNSS might not have been added, and the only purpose of adding the said provision was to make the case against the petitioner more serious in nature. He also submits that if section 317(4) of BNS as well as section 143 of BNS is not found to be attracted then the remaining offenses would entail issuance of a notice under section 35(3) of BNSS to the petitioner. Stop. Learned counsel for the petitioner has also submitted that the petitioner has not indulged in any online gaming or gambling, and also not indulged in online betting. He submits that a report may be called for from the investigating officer as regards the progress of the investigation regarding what was your submission?
Regarding, my lord, regarding online transaction, the amount of
The amount of online
that is why they are
transaction,
doing further investigation, not further investigation.
online transaction done in the alleged, done by the petitioner during the commission of alleged offense as
Offline may be used also, because no cash recovery.
he also submits that in this case, the cash which was recovered is of very small amount, which was found in the wallet of the petitioner. And apart from that, no other cash amount was recovered. He submits that had there been gambling and betting, some cash would have been recovered. He also submits that the petitioner is an advocate by profession, practicing at the Aizawl bench of Guwahati High Court, and there is no flight tricks, and he is ready to cooperate in the investigation. Therefore, he prays for allowing the petitioner to go on bail. On the other hand, Mr. B. Sharma, learned additional public prosecutor, has vehemently opposed the grant of bail to the present petitioner. He submits that there are sufficient materials against the petitioner regarding his complicity in the offense alleged in the FIR. He also submits that the victims whose statement have already been recorded have categorically implicated the petitioner in the offense alleged in the FIR. He also submits that it is the petitioner who had booked 32 rooms of the Club Nirvana Resort, and it is who has organized the gaming and betting event at Club Nirvana Resort. And he submits that evidence to that effect are there in the case diary. He also submits that the investigation is going on at a very crucial stage. And if at this stage the petitioner is released on bail, it would certainly hamper, it would hamper the investigation, and hence prays for dismissing the prayer for bail. I have considered the submissions made by learned counsel for both sides. So, remaining on day after tomorrow, heard Mr. BK, এইখিনি type kori মুখ দি দিব. Heard Mr. BK Mahajan, learned counsel for the petitioner. Also at Mr. B. Sharma, an additional public prosecutor. Let this case be listed for delivery of orders on 6th of August.
Highly obliged.
Please, your lordship. Look, in this case, some instruction,
I tried to take the instruction about service of notice, but I could not communicate to the IO. So any other day, tomorrow.
Take some time. Heard, Mr. This is item number? Heard, Mr. A.K. Azad, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who seeks some more time to let this court know about the fate of notice issued to the respondent number 2. The prayer is allowed. See, day after tomorrow. This matter on 6th or 7th? Okay, 6th of August. Yes,
May I please, your lordship? My lord, I for condoning the delay of 132 days.
100 and
Basically, 32 days, my. Basically, it is my lord appeal against the acquittal.
appeal against acquittal. You are for the
Respond number 1 and 2 and 3, lordship.
accused.
Or accused.
What is your submission?
Ground lordship, the applicant came to know after acquittal, after when the accused person visited the house of the applicant and said her that he will take revenge upon the applicant. That is why basically he filed this appeal. So,
No, that is
I
not
mean,
the.
para number
that is
3,
the
lordship.
ground of the IA. That is the ground.
Delay.
How you can know, my.
No, after condoning the delay, you have again to take leave. Leave is required or not? No. This is an appeal under section, what provision? 378.
430. Yes.
400 and where is the appeal against acquittal? Which provision? You are victim. You are the victim. Okay, then no leave. Then what is your submission?
I have stated my ground that there are 3, my lord. After passing the judgment, my lord, when the accused persons, they were acquitted and they visited the house of the victim.
When?
My lord, that was my lord on 27/6/2024, and judgment and order was passed on 22/3/2024. And on 27.
Then when this appeal was filed?
October 2024.
So on 28/6 you came to know, still there is delay. Even if we, 6, 7, 8, 9, still it is beyond 90 days. Suppose we assume that that you came to know about the conviction and sentence on 28/6. When?
27/6, my lord, he came to learn. And on 22/6/28, my lord, he applied the certificate copy.
How much time it took for uh, for getting certified copy?
On
1724.
1724, my lord, he obtained the certificate copy.
Only 3 days.
3 days. Collect the certificate.
So from 1/7, whether within 90 days you have filed appeal. Okay, what is your submission? Yes. What is your submission?
Lordship, it is clearly stated that Lordship, he received the copy 17 and filed for 10. So that is also after 90 days, Lordship, after completed the stated period, Lordship.
That is, that calculation has been done by the registry. The implementation period, my lord, that is perhaps on the record.
So in this year, I will file objection, Lordship.
Has not been done by me, my.
You have filed objection.
Yes.
You have already filed or you will be filing?
No, Lord. File.
You have filed.
File.
Where is the objection?
Or I will file, I will file this, not file.
You are seeking leave to file
Yes,
objection. Okay. Let him file objection. Heard Mr. S.A. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. As well as Mr. What is your name?
Jai Ahmed.
J.U. Ahmed, appearing for respondent number 2 and 3. Learned counsel for respondent number 2 and 3. Praise for allowing the said respondents to file a written objection against the prayer for condonation of the delay made by the applicant. The prayer is allowed. Let this case be listed when on 18th of August, on or before the next date, the respondent number 2 shall file his written objection.
Apply. 50.
Yes. You spoke so case.
Also, yes. I've seen behind the person last more than 1 year, sir.
Were there any amicus?
That's why
Amicus was there.
it's just outside the.
He's still there. Find out.
3 minutes ago.
If she's not there in the corridor, we will, okay. You are ready? Let her. You will be opposing the IA. What is the punishment?
5 years.
Okay.
No,
Heard.
1 year behind it.
Heard Mr. A. Khonikur, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, as well as Ms. M.K. Brown, learned amicus curiae, appearing for respondent number 2, who seeks an adjournment on the ground of personal difficulty. The prayer is allowed. Let this case be listed.
Next week.
You want a fixed date
I want to
on 12th August.
deep blue. Project delay condition application project. Total delay is of project 94 days. After considering the statutory period, it will be 32 days project.
Why that delay was?
Actually, sir, after passing of the order, judgment and order, the council applied the certified copy on 16/12. It was the judgment was passed on. Judgment delivered on Lordship 22/11/2024.
How many days delay? 30? You are opposing?
No, my lord, regarding 32 days, my lord,
Okay.
statutory
Heard Mr. S. Sharma,
Lordship division.
B.P. Sharma, learned counsel for the applicant. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant Muhammad Mofizur Rahman alias Suzan, praying for condonation of delay of 32 days in preferring the connected appeal, whereby he intends to impugn the judgment and order dated 22/11/2024 passed by learned Sessions Judge Ojai in Sessions within bracket 1 within bracket 18H of 2021. You were convicted, whereby the petitioner was, present applicant was convicted under section
N is 326. 10 years. And fine of rupees 10,000, other 326.
Lordship page 15, Lordship. Is there is sentence imposed.
What are the provision under which you are convicted? Under what provisions you were convicted? You must know under what. Be louder.
353, Lordship.
Only 353. What is your name?
BP Sharma.
No, the appellant's.
Mofizur Rahman, Suzan.
Mofizur. Convicted under section 326 /333 /149 of IPC 149/143 /147 /148 /447 of IPC. Along with section 3 within bracket 2 of PDPP Act and section 4 of the Assam Medicare Services Persons and Medicare Services Institution Prevention of Violation and Damage to Property Act 2012. You are convicted under 12 counts and some other provisions of law. Stop. Learned counsel for the petitioner has submitted that the petitioner, learned counsel for the applicant has submitted that the applicant was prevented due to reasons mentioned in which para you have mentioned the reasons? Reason for delay.
Starting from Lordship, para 4.
Mention in paragraph 4 of the application for condonation of delay, comma, in preferring the connected appeal within the prescribed period of limitation. He submits that the reasons shown by the petition applicant may be considered as sufficient reasons. Under section 5 of the Limitation Act 1963. On the other hand, learned additional public prosecutor, considering the reasons shown by the petitioner in his application for condonation of delay, has not opposed the prayer for condoning the delay. As the stop, I have considered the submissions made by learned counsel for both sides. As learned additional public prosecutor has conceded to the prayer for condoning the delay made by the applicant, and as the grounds shown by the applicant in the delay condonation application, which prevented him in approaching this court within the prescribed period of limitation, is found to be sufficient cause by this court, comma, the delay of 32 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry to register the connected criminal appeal and list the same for admission on a date to be fixed by it. This interlocutory application is accordingly disposed of.
Deeply.
I just give you.
Yes.
This I for my lord seeking bail is convicted under section 8 of POCSO for 3 years.
Notice will go.
It's already issued. He is in custody.
Heard Mr. H.A. Ahmed, learned counsel for the applicant. Also heard Mr. K.K. Parashar, learned additional public prosecutor. the office note dated office note dated 24/6/2025 shows that the notice has
My instruction, my lord, as per my instruction, they have received. my lord.
no, you take telephonic instruction. 24/6. Supplementary files of Putul. Notice con last. Report আছে নাকি? Service report is not there, na? কি লিখলে? Has been issued to the respondent number 2. However, no service report has been received. Stop. In view of above, learned additional public prosecutor Mr. K.K. Parashar is requested to get information regarding fate of the notice from the officer in charge of jurisdictional police station and let this court know about the fate of the notice on the next date fixed. Let this case be listed on when on 11/8/2020.
Item 53.
Yes, my lord, we are appearing as legal aid counsel, my lord. There has been delay, my lord, about, my lord, 850 days in filing the appeal.
Appeal against conviction.
There 4 under section 4 and 8 of POCSO. 10 years.
Yes, notice has to go. Notice has gone. You find out whether notice has been served. Otherwise, we'll appoint third Mr. B.K. Sen, learned legal aid counsel, appearing for the applicant. Also heard Mr. K.K. Parashar. It appears from the office note that till date, the service report unserved notice. No, notice was served. No, No, office note dated 24/7/2025 that unserved notice has been received by the registry. On perusal of the report of the officer in charge of Fatasilambari police station, it appears that no one with the name of the addressee mentioned in the notice was found in the address given, and therefore the notice could not be served. As the notice on respondent number 2 could not be served under the circumstances mentioned herein above, this court is inclined to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Suggest a name who. Who is T.R. Deuri? Ujjwal Chaudhary's name is not there. Rakesh Sharma. Rakesh Sharma. Accordingly, Mr. Rakesh Sharma, whose name appears in the panel of amicus curiae prepared by the registry, is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. Let a copy of interlocutory application along with memo of appeal be furnished to the memo of appeal and annexures be furnished to the newly appointed amicus curiae. Let also the name of Mr. Rakesh Sharma be reflected in the cause list henceforth as amicus curiae for respondent number 2 in this case. List accordingly. After a week on a date to be fixed by registry. Registry will fix a date. Or you want me to fix? Suggest. Suggestion. 13th of August.
Like, if you
Finish.